Oh, so Cheryl was done.
So she thinks that his first resolution is think about what she said.
That's what they do.
That's a little loony. But think about she created that story like, do you see what I'm trying to
Right,
say?
I understand exactly what you're saying.
And I believe that. She's always been.
I mean, he said that she's in that.
So she tells me and Jim and my dad that when you're in an ambulance and everything, if you hit your flash your highlights at the lights, the red lights, they automatically
Jim said that?
think about it. Think about it because,
Well, you gotta go through the light. Maybe they know the family.
as you'll recall, last month we had a work session where we talked in more abstract terms about general policy directions this body wished to move into as it relates to short-term rentals and their regulation and operation in the city. During that discussion, I received consensus direction from you, extensive public feedback, both in the form of written submissions and statements made via Zoom or in person. I took all of that into account, and with that have produced an ordinance for your review and discussion tonight. The goal of this is to get us to a final product so that when we get to first reading, the process has been distilled to at least what policy direction we really do think we want to go, and you having the opportunity to meaningfully deliberate on ordinances that are of great importance in your community. Since we had that workshop, there has also been another development in the form of legislation that's been filed. Senate Bill 714, I believe is the number. Senate Bill 714 has been filed that would change some of the landscape as it relates to short-term rentals. For example, we had extensive discussions about what the registration fee would be and what an appropriate amount is. According to the Senate bill, if passed, and it is only proposed now, it is not the law, but were it to be adopted, that would be capped at $50 per registration or $100 for collective registrations. That would be state statute. The statute does explicitly contemplate the power of the municipality to have a registration program and operate it and condition it on various elements. Some of the things in Senate Bill 714 that it addresses that preemption and explicitly stating a local law, ordinance, or regulation may require the registration of vacation rentals with the local vacation rental registration program. So eliminating, to the extent some litigants have argued that, well, that's not clear in there, it's not stated, making it more explicit. Local governments may charge a fee of no more than $50. The registration can't be any more frequently than once per year. As a condition of registration, there's a list of things we may only require. Of course, if this were to be adopted, we would have to make sure that anything is harmonized. And then it also has some of what the contents for an application of a license can be. And finally, of note to us, in addition to regulating, it independently regulates advertising platforms, and it also has a provision for the Division of Business and Professional Regulation to revoke or refuse to issue or renew suspended licenses. What I would say is this is again proposed legislation. It was filed, I believe, February 12th or 13th. Session does not start until Tuesday. We are not in session, the committees have been meeting. Session runs from March 7th to May 5th. So there's plenty of time for the provisions therein to be amended, either be adopted, rejected, die in committee, any number of things. My advice to you at this stage is to continue to forge ahead with whatever policy direction you desire to move in. And if we need to adapt to the state of the law, we will do that, as we have in another instance that's been brought to our attention. And so I do want to make sure that the body is aware of that in the event that informs any of your decision making. As the mayor alluded to, you have a draft ordinance that is proposed. This is not first reading. This is in fact a work session. So for those members of the public who are lucky enough to be unfamiliar with our process, this is what this body, as I stated at the last meeting, can only meet and deliberate about substantive policy in an open meeting like this. So they've not been meeting with each other in the intervening month. This is their first time to reconvene. In that intervening month, I've been working with staff to get this work product to them. And this is not, what you see proposed here will not go into effect tomorrow or anytime in the near future in terms of days or weeks. What will happen tonight is we'll make sure that this draft is what you folks want based on the feedback and your own thoughts. We will, just as we did last time, go page by page or at least section by section, make sure we haven't overlooked anything, and that if you wish to address anything, once this body has had an opportunity to deliberate and provide whatever consensus direction you intend to provide, we will open it to the public. Last time the way we did that was we alternated between Zoom and, man, that is a handsome guy there. We will alternate between Zoom and those members in person to discuss the contents of and policy direction. And then at a later date, we will come back for a first reading and then a second reading. It takes time. And so with that, Mayor, if you're comfortable with it, I'm prepared to proceed through the ordinance. The first 3 pages are the whereas clauses. Those are there to substantiate as findings the positions that you, and policy direction you're moving in. I'll just more broadly ask if there's any feedback specific to the whereas clauses other than just ribbing me for how many there are.
There are quite a few. Anyone have anything for Randy on the whereas?
All right. So then moving past that, we go to the definition section. Some of the revisions of note. Looking at the definition of a bedroom, one of the citizen feedback points that was raised, and I think feedback that was well taken, was the unique feature of having cottages in your community, and some that have not historically had incorporated closets, and a closet is part of the definition of a bedroom. And so there was language provided that for purposes of this article, staff shall have discretion in the registration process to determine the number of bedrooms within traditional cottages that exist within the city, but may not have a built-in closet owing to their historical design. So there will be some discretion there. It does allow for that, not work some kind of legal fiction where they have no bedrooms in a cottage just by virtue of the absence of the closet. So that was one substantive edit there. Another was a property shall not under owner occupied. Some feedback both from this commission and the public, adding language that a property shall not be deemed owner occupied where the owner of the property allows a friend, acquaintance, employee, or other person not considered a family member, as defined there, to occupy the property unaccompanied by a family member. So if I have a property and I just say, Phil, you can go ahead, you're not paying me, but you can use it. For purposes of this, that's not owner occupied. The owner is not, in fact, occupying the premises. So that's some of the more substantive changes within the definitions, but before we move on from definitions, is there any remaining feedback or concerns that any member of the commission has?
Any questions for Randy? No. Hearing none.
All right, the next one is 18-201, the scope. This, as written, applies to vacation rentals within each of the city's zoning districts. There is a narrow carve-out for, and I believe there's only one property meeting this description, for properties within the city's CT zoning district that are historically timeshare properties, given in part the administrative, one, that they've historically existed in this way and have not historically presented an issue in that regard based on their intensity of use, but also the idea that every individual owner of a one-week interest, one, I don't know that they could get to 3 rentals in a 30-day period to get there, but if they intend to register in that fashion, it could work somewhat of an absurdity or a challenge. And so there was a carve-out made for that based on the historical use of the property and the issues addressed in the ordinance. At this stage, I know there was a substantial citizen feedback on which districts should or should not be incorporated, and Coke versus Red Bull or Red Bull with vodka, I don't know. But whatever you folks think most appropriate as far as the scope of this in your zoning districts, is there any feedback, concern you wish to address now that you see it in print?
Do you want to start?
Is this the only carve out for CT zone as far as the ordinance?
Presently, ultimately, you folks decide what the carve-outs are. If you, I know that there was substantial discussion and debate last time about whether the CT district as a whole is best fitted into this regime or not. Ultimately, that's a decision for you folks to make as the policymakers. I understand the comments made about the historical and traditional uses of that district and how they may be inherently distinct. I also know that there was feedback to the contrary, saying all of our districts suffer these ills, and ultimately how that's resolved is up to the 5 people.
Yes.
One of the things that I was asked about today, and I provided a copy to y'all just as a reminder, the current ordinance that we have, the limits of where it applies, so I just get that to you as a reminder. It's basically the east side of Gulf Boulevard, everything north of 5th, and the only thing that's excluded on the east side of Gulf Boulevard are the commercial properties that front Gulf Boulevard. So that's where the existing ordinance applies. The way this is drafted right now would apply in the entire city. So that's, just remember the differences between the current ordinance and what you're talking about now.
I think you remember that when we discussed this, we were very hesitant on it. When we discussed this at the last meeting, we were very hesitant on putting all the districts together, and once we made made a decision to put all the districts together. I know I rethought it, and I've had a lot of feedback from residents. And my thought, and Joe, you can also, and all of you make comments about it, is I think the best thing for this ordinance is to just exclusively do the residential district that we have, mirror it. And what do all of you have any comments about that?
I think it's certainly worth considering.
Go ahead, Jude.
Joe?
No,
Yeah,
go ahead.
Thanks, Joe.
Just one kind of question I had that kept coming up. And I saw we got a couple carve-outs. Can maybe Randy be best give me a better understanding on how this impacts our condos that line the Gulf? Because they have their own HOA, they have their own rules, they have. So how does this dovetail into what they're already dealing with? I guess.
Excellent question. To the extent they have their own condominium association or homeowners association, and I don't mean the IRB, I mean specific to a unit or building, the city doesn't enforce their homeowners restrictions. That's for them to enforce. That's why they have their own condo boards or associations. They are responsible for administrating any restrictive covenants they have in their own documents. As far as how this applies in its present iteration, it applies in those districts. The ordinance as written applies in those districts. There is another narrow carve out in the current draft in the parking section where it says we're not going to make a giant condo building that has a parking by unit whatever arrangement suddenly erect a new garage or somehow alter. I know that's a third rail statement, so I'll just say somehow alter their parking arrangement to accommodate the restrictions or requirements of this ordinance. That's really the only other exception made within this. What I would say is, to the extent, for example, if I own unit 143 in this condominium and I'm the only person who wishes short-term rent and that doesn't somehow violate my restrictions, I would have to register unit 143 with the city and be subject to all the same inspections and everything else that go with renting that unit, subject to, and I know the fire chief has made some exposition about how that might be slightly different because there's shared elements and baseline safety requirements in a building like that, but generally speaking, as written, it applies to those units as well. Okay, thank you.
Can I ask for an elaboration on that, please? So just quickly, so then does that mean that if we include the CT zone, that basically if we enforce if we apply this to the CT zone, does that mean that it basically allows the state to again preempt the decisions of, say, the HOAs or the condos? Like right now, if we don't touch it, can the condos make their own rules? The HOAs over there and the condos make their own rules.
The honest answer to that is I don't know because that's not who my client is. What the condos, I understand there may be some, and I know and part of the I don't know is I know there have been bills proposed that would limit HOA restrictions as they relate to short-term rentals, and I don't know if those have been adopted because, frankly, whether or not they can adopt them doesn't change what we do. And to the extent you're talking about it as a question of preemption, our powers are derived from the state. The state can take those away regardless of what we do. They can preempt us tomorrow on most things if they so desire. And so whether or not we adopt something doesn't somehow imbue the legislature with more power to preempt. It inherently has that power. So we're not granting them some leeway in that regard. I don't know if that answers your question, but that's at least how I was understanding it.
Yeah, but it does. But it would not immediately allow for it.
I don't know what the "it" is in your statement.
Short-term rentals.
Well,
if they're restricted by an HOA.
if they're restricted by an HOA, again, to me, that's just beyond our calculus. We're here as the city, and we are enforcing our code of ordinances, our charter, our comp plan. But restrictive covenants within deeds are for the property owners and their associations to administer, not for the city. I mean, lived in an apartment. I've been fined for too many balloons on my door and other things. You know, that ultimately that was a function of the rules of that building, not the city I was living in at the time.
Phil, Denise, anything you want to add to that?
Well, I think, I'm the one that sort of brought it up. It's like, let's just do the whole island. Let's not separate it from residential to the CT zone. I think that most of the people in the CT zone already operate by a set of rules because they're used to renting to short-term people. So they've got their noise under control. They've got, their problem customers under control. The only concern I have is then we're missing the opportunity for inspection.
Greg, do you want to say anything to that? Because we've had that
The
discussion.
only opportunity we have for inspection under the current ordinance is in May. There's not a required inspection. Now, since the November meeting for all new vacation rentals, I've required the new ones be inspected before we issue the business license. But we don't have the ability inside of City Hall to inspect properties on the west side of the road anyway, because they're not covered by this ordinance. Now, and the fire chief can speak up for his department, but my understanding from the fire chief is, they're maybe give an update at some point about their ordinance and where it is. But their intent is they're going to inspect all vacation rentals throughout the whole city. So there's a difference in what we're doing and what they're going to do. And currently, as it stands, as we sit today, none of my code people that work for me are not involved in the west side of the road because the ordinance we have does not apply over there.
But they will have to have a business.
They should have, and I'll just say publicly, we're aware that there's a large number of vacation rentals on the west side of the road that do not have business licenses. But that'll be addressed either way. If you adopt it, whether you include it or not, we have plans to address the lack of business licenses with properties on the west side of the road.
What, Joe?
Probably one of my largest concerns, because if you remember, I was not a proponent of the CT zone at all. I guess one of my concerns is if we don't have any limitations, be it occupancy, be it whatever, like all our cottages, everything we've tried to save over the last 10 years, they're getting taxed out of the world at highest and best use. Their insurance is through the roof. They're going to sell out at some point, right? They have to. So, do we want developers to come in, like have come into other cities and put in 10-bedroom, 10-bath Airbnbs along the beach? Fit 50 feet by 100 feet type of building in that area.
I would just advise that is sort of development permissions and development requirements are separate and distinct from regulating the operation within that structure. Just making sure.
Yep.
Manager Lynch, did you have something you wish to add to that?
Yeah, just to clarify part of that too, is that particularly on the CT, really throughout the whole city, particularly on the CT, you're only allowed to develop a certain number of units based on the size of property that you have. So to take I just want to keep that perspective, to take the view that I can take my 50-foot lot and cram as many as I need, there's a square footage requirement for each unit, so automatically you're limited on having. So where that happens usually in Florida is where people go in, they take a residential property or an unzoned property and they build a mega house with 20 rooms.
Right.
But there's limits inside the city. It's all based on square footage per unit. So the idea that on the west side of the road that somebody's going to take a 50-foot lot and you're going to build, blaming it on you, you're going to put 20 units there. You're not putting 20 units, because you have to have square footage that goes along with that, so that really can't happen.
Appreciate the clarification. Like I said, in my original, that was obviously one of my concerns. As far as my original thought process of the CT zone is with the cottages, with the different variations of property, the condos. I think it operates the way it should, to be honest. Now we have some problem children over there, obviously. Some houses that may need to deal from a compliance standpoint.
Well, and we've been made aware of those too.
Right. I mean, that's, if we don't include it, does the city have the teeth to rectify those situations?
Greg?
What are the situations?
Just if there is noise, trash, some of the same things and issues we're dealing with on the east side in the neighborhoods. If they're happening in houses that are not condos.
Yeah, we have the tools in the current ordinance to deal with those, and we do deal with those.
Okay. I just didn't want to leave this,
No, that's,
right?
do we have a consensus? What is the will of the commission? Can we separate this ordinance that we are working on as far as the residential part of the community? Do we have a consensus on that, or is there some other way, something else that you would prefer to do? Yes.
I think that Joe brought up a good point. There are a lot of single-family homes over there. There are developers coming in now and they're building structures specifically to become Airbnbs. Originally, when the short-term rental law came into effect, condos that had HOAs were excluded, and they may have changed that since I've slept last. And the way they changed things up there, anyway, it happened at the time. But I do think that it's important to call into this residential zoning fabric we're working on right now, is if it's a single family home in the CT district, it should fall under these same guys. If not, we don't have any real power to affect it. So maybe if you do another cutout, maybe it specifies that, unless they're covered by an HOA, i.e. a condo. Would that simplify it?
I think that makes it more difficult.
Yeah, I was gonna say, I think it
Well,
just.
that's what I'm getting, so I
It's his last one.
You just tried to throw a bomb.
Yeah.
That's just how I see it. So do what you want.
Yeah, I mean, there are obviously already, there's currently a cottage that was torn down on the beach that's being built into two separate buildings that are condos, and that's fine, that's what they do, but there was a cottage on the beach, and now there are two big buildings. So Joe's concern is reasonable, given that that's sort of part of the fabric and the nature of the town that everybody loves. So we do want to perhaps not encourage short-term rental development on the beach side where the cottages are. That is certainly something to consider, and maybe it's best to do less than more right now in terms of addressing, maybe that's a problem to address for another day if it is in fact a problem.
Do we have a consensus then? With everybody that we will separate the residential, okay, and the district, the residential district, I want to make sure that's clear in the document.
Speak up, please.
We can't.
What we are saying is, if you're standing and you can't hear us, there's 3 chairs in the front that you can move up to, if somebody would like to move up to the front.
They can't hear back there. Nobody can hear back there.
All right. Are we clear on that?
Yeah, to
Is
separate.
everybody separate? Okay,
Yep.
are we all clear on this?
Yes.
Okay, all right, thank you.
One moment, I want to make it clear. So, for those who couldn't hear, the issue being discussed as to is the scope of where this ordinance will apply. There seems to be a general direction towards excising the CT district from that scope. My ask of you would be to make clear presently, as Manager Mims indicated a moment ago, your present ordinance applies in the residential district and in that area outlined in blue on the map he provided you, and does not include, for example, the business triangle or business district. However, I know different people use different nomenclature, or the PUD that exists to the south there. And so is it your direction that we include the same scope as the current ordinance, or something, is it everything except CT, or is it just those residential districts? I want to make sure that that when we come back on first reading, we are clear on what it is that you're seeking, where you intend to have this apply.
I would say just residential, because that's essentially where the issue is for everybody. So, I mean, they're zoned separately for a reason.
I agree.
I agree. So would their registration fee stay as $10 on the CT zone?
They would only be paying for a business tax receipt, because they're not going to be subjected to the vacation rental registration process
Okay.
as contemplated in this ordinance.
Okay.
Whatever the sum of that business tax receipt is a different question, but it would not be the same sum, because they are not pursuing a vacation rental registration.
Okay, let's proceed to the next.
So the consensus is only residential that's included in the ordinance.
Got it. The next section is the section. The consensus direction was for the scope of this to apply in the existing scope of the present short-term rental ordinance, which is limited to the residential districts. Again, this is not a first or second reading, but it is direction for what will be presented. The next is the enforcement section, 18-202. Another point of feedback that was substantial following the last meeting was concerns or questions about, I don't remember us talking about fine amounts. I don't remember a discussion about, the particulars. And at the time during that workshop, I said, I just want to know what potential penalties or provisions you intend to have as part of your enforcement. There was general consensus direction that, of course, fines as contemplated in Chapter 162 of the Florida statutes, but as well potential suspension and potential revocation. And so I've codified that general understanding, but what I've done is couched it in this draft much in the same way that most code ordinances operate, which is you will have a quasi-judicial hearing before a special magistrate. And we've received RFP responses and we're working towards that stage. But once you have that special magistrate, the better practice, rather than fettering them to a very specific penalty every single time, is to allow discretion based on enumerated criteria. And so we have enumerated criteria, and the way it reads is the magistrate's decision whether to impose a fine and the amount of the fine shall remain subject to the provisions, considerations, and limitations set forth in Florida statute, which are the first three on this list, by the way, as well as the following factors: the gravity of the violation, any action taken by the violator or property owner to correct the violation, any previous violations committed by the violator, the property owner or designated responsible party's efforts to resolve or avoid the violation, the temporal duration of the violation, how long did it go on for, sustained or intermittent, whether the violation was a function of the property owner's action or inaction or those of their transient guests, any evidence of the property owner's adjudication or admission to violations of a similar nature in the city, any evidence of deliberate misrepresentation by the owners to the city or its agents in connection with the violation, and any documentation from an online rental platform of any warning, rebuke, censure, suspension, penalty, or prohibition of the property owner or owner's use of its platform for the purposes of offering properties as transient public lodging establishments as a violation of that platform's policies, procedures, or terms of service. And so those are the factors that would be considered in imposing, determining whether to impose a fine and the amount of the fine. Then, provided a fine occurs, it has here upon a third adjudicated or admitted violation of the city's code of ordinances within a 12-month period at the same rental unit or property, the magistrate shall have the discretion, again it is not automatic, it is discretionary, to temporarily suspend the property owner or owner's vacation rental registration for the property or unit at issue. The magistrate's decision to suspend the and I'll catch that Scribner's error of the apostrophe S, decision whether to suspend the vacation rental registration and for what duration shall remain subject to those same factors. Enumerated in the fine factor, those same things will inform whether suspension is appropriate. And again, the spirit of that goes to some of the discussion of this commission and the public had about, you know, if my trash is out 2 or 3 times versus somebody's, you know, launching cannon fire from the backyard in the morning, should those be treated equally? And that discretion is afforded there. The final here, I made it explicit in part because there was a lot of misapprehension about how this was worked. So I want to read this language. Nothing in this provision shall be construed to permit for the suspension of a registration based on mere complaint or alleged and disputed or unadjudicated violations of the city's code of ordinances. The magistrate's decision whether to suspend a vacation rental registration and for what duration shall be subject to the same considerations for the imposition of a fine as set forth in this article. So making it clear that just because somebody calls a violation in does not count to that tally. It has to be either admitted in the form of a clear admission or a paid violation, or an undisputed paid violation, or a magistrate adjudicating a disputed violation and it being upheld. So that's the criteria for that. And then it also provides how that license returns upon the suspension of the period. And then finally, revocation is upon a third imposed and legally sustained suspension. So if you appeal it and it's overturned, that doesn't count. A third imposed and legally sustained suspension within a 3-year period, the magistrate again has that direction based on the same criteria. And so that's how to the extent there was a lot of question, I would say this is where the most language was added to the draft from what you saw last time, where the detail really was supplemented substantially. So I wanted to make sure you're clear on that. And again, I welcome any feedback, questions, concerns you may have.
Any questions for Randy on those? Joe?
I think he was speaking directly to me.
It's all good. It's all good.
Those were my questions. Thank you, Randy.
Yep.
All right. We'll move ahead.
All right. The next is appeals. I would tell you that's not really something that you should probably mess with. It's just an aggrieved party. It acknowledges the statutory right to an appeal and going to the circuit court and how that works. So it's really a recitation of statutory language. And again, that's a function of due process. I understand for some neighbors, residents, people observing things, the legal process is often frustrating, but acknowledging people's due process rights and abiding by them is how this all works. I have litigated many a code enforcement appeal, just for the benefit of this group and those present. If somebody challenges a code enforcement adjudication, the way that works is it goes, especially one of the special magistrate, it goes to the circuit court, so the courthouse. The judge handles that appeal, and they look to whether they were afforded sufficient due process, which is notice and an opportunity to be heard. 2, whether the decision abides by the essential requirements of law. If you're enforcing against them for noise, but you're reading from the fence height provision, you've deviated from the essential requirements of law. It's going to whether or not you're reading from the right sheet of music for the violation at issue. And then the third is that it is supported by competent and substantial evidence. So they're going to look to the record. On appeal, you don't get to argue new things. It's confined to whatever either party, city and violator alike, have put into the record. And so that appeal provision is an explicit recognition of that legal process. That's not something we're creating. It's an acknowledgement of an existing process. The next page is, we're on page 8 of 23 from the draft that I circulated. The next part is the registration requirement. For those of you reading it in a color printed version, there's a few highlightings in yellow. Those are just placeholders based on how this process moves along, noting that, you know, if this is adopted in June, those dates will likely have to change, and we want to be mindful of also what's practical. The next is the vacation rental registration fee. This was a substantive change from the last draft. You'll notice in reviewing this that there is not an explicit number in the vacation rental registration fee. Generally speaking, especially keeping an eye on the way the legislature continues to preempt or otherwise regulate registration fees, not just for short-term rentals, but otherwise, your better bet is to have your fees in a resolution, separate from an ordinance. A resolution doesn't require 2 readings and a newspaper ad and all of these things. And so if, for example, we adopt a sum, and the last sum that I recall, and please forgive me, I don't have the note in front of me at the moment, was approximately $400. You're not going to see that $400 anywhere in this draft. It would be in a resolution that would go with it. But let's say we adopt this, and then that Senate bill that I told you about is adopted. We would just have to do a resolution amending our fee structure from the $200 or $400 to $50. I would just ask, while we're there though, while there will be a resolution, it is going to need an amount in it. Are you still comfortable at that amount, subject to everything else I just said? So the $400 is the rental registration fee. Is that still what you're thinking based on the draft, especially because it will have to be in a subsequent enactment?
Is that, on a multi-unit, is that 400 per unit regardless of the number of units? Sorry. Is that 400 per unit?
Yeah, the question was in a multi-unit, where you're registering multiple units, is that 400 per unit or per building? I would say, and certainly that it would warrant addressing that explicitly in the resolution that comes with it. As contemplated, it would be per unit or structure. So if you have, the reason I'm saying unit or structure, if you have a condo where you have, let's say, 6 units that are owned by separate people, each of those is going to be separate. You folks have not given me any instruction thus far that if it's Jude owns 6 units in that building and he wants to rent all 6, whether there's some kind of cumulative cap. Thus far, the explicit direction actually was discussed at some briefly, and it was just make it from a unit, make it clean, and that's fine because we're still going to have to inspect those. We're still going to have to register them and fill out paperwork as to each. And so the instruction thus far has been every unit pays those $400.
In this proposed legislation, though, there is a cap for multiple units. Is that correct?
Correct. In the current draft of Senate Bill 714, it's $50 for 1 or $100 for a group. That is not a dichotomy or distinction made in this current draft.
Yeah. So I don't know if that's something you guys want to consider. If you've got 16 units, is that 400 times 16, or is it?
Just for the benefit of all, and especially our Zoom attendees,
My apologies.
please speak into the mic.
Sorry. Yeah, if you're, in my opinion, if you're registering unit A, B, and C, those are 3 different revenue producing units. Whether you own them or 3 different people own them makes no difference. So I would say it would be per unit. And I'm okay with the 400 at this point, unless the state tells us different.
And understanding that that's less of a concern based on the current direction you're moving, where it's only applicable in the current districts and not within the CT district, for example, where you're more apt to have multiple units. Now you may have property owners who have multiple structures, or an LLC that has multiple structures, and so you can still have multiple registrations. But to the extent that your concern is unit 110, unit 112, less apt to see that based on the policy direction you're presently going. All right, with that, the next is the registration process and contents. Consensus to sustain in the current direction, no changes. The next part is 18206 on vacation rental registration process and contents. The most that I did here was just try and synthesize to the extent things were repeated across sections, try and organize them under subheadings. That a registration application is required, what's part of the submission, what is part of the registration contents, and it goes into that. Now there is some language in the statute on what goes in registration with the DVPR and otherwise, and if there is a deviation, we'll need to harmonize them, but presently that's just a proposal. So I don't have anything specifically that I had of concern for your input here. So there were some limited additions, ADDITIONS additions, one of which was adding things to the list of items that would appear on an exterior site plan, for example, an outdoor kitchen, and other things, again, based on general feedback. But other than that, I did not make any substantial edits here, and unless, of course, any of you saw anything in here you wanted to address. All right, with that, we'll move to page 10. It makes it explicit. We're still within registration requirements, just making clear that a complete submission is required. Somebody sending you, like, I put my name, I put my address, that's all I'm going to do, process it. That it won't be processed if it's incomplete. And it also clarifies how to dispute. I think it's complete. The city's telling me no. If that needs resolution, I'll go to the magistrate and provides a timeline for resolving that. But the last thing that was added here is to say that a completed vacation rental registration shall not be approved until the subject property or unit has completed and passed the inspection process set forth in this article. So the registration process explicitly contemplates the inspection process. I will tell you, one of the provisions in Senate Bill 714 that may impact this, depending on how it proceeds and whether or not it is in fact amended in any substantial way, is it does provide a sort of automatic approval period if something is not approved within 15 days. And we would have to harmonize and determine how, one, it all depends on how it's written by the time it gets across the finish line, if it gets across the finish line. But that is something I want to make sure you're aware of, that it's kind of got the sort of the inverse of the pocket veto. If you haven't taken action on it within 15 days, it's deemed approved on a registration under the proposed legislation. So other than that, are there any other questions within 18-206, questions or concerns?
That's inspections, correct?
Next is 18207. That has the hat tip to inspections. Inspections as a provision are independently appear in 18210. So we're not quite there, but it sort of acknowledges that process exists.
And this may be too specific, but just something as I was reading through it and thinking of, if the way our registration process works, it sounds like you are currently the owner, you gotta provide the deed, you gotta do this, you gotta do that, to get to that inspection, right, which can make or break a house. I would like to see us have some sort of opportunity or option if I'm a prospective buyer on a home here. Say I'm a snowbird and I do want to rent it sometimes when I'm gone. Can we have a provision for the city to do an inspection on that property to make sure it's compliant?
I totally understand your point. I'm trying to think through the practicalities of that. If I'm the seller, likely I'd be incentivized to give access to the property.
Sure.
I might not, which is part of it. The other concern is I have a little reticence about the reliance element of that if they're going to then claim that, I made a $1.2 million investment or $400,000 investment based on a preliminary inspection. And, to say nothing of title insurance and how all that fits in. But I hear that feedback and I welcome whatever direction you folks want.
I would say that just as one gets an inspection before one buys a property for any other reason, you just fold that right into it. Say, hey, I'm thinking about buying this for a rental, so, is it compliant?
Right, and that's done privately.
Yeah,
Typically.
exactly.
You're not
Yeah.
bringing in a government official
Exactly.
to determine whether or not you should buy a property and it's consistent with, flood and wind. Most people have a private entity they hire to do their forepost or whatever you call it. If you wish to, or maybe that creates an opportunity in the marketplace, I don't know, for those private inspectors to say, oh, I'm familiar with it and do that. But I would have some hesitation based precisely on how that otherwise works on making that a duty or burden of the city. So no consensus to add that to this, is that correct? Okay, all right, thank you. With that, 18-207, modification, change of ownership, sort of narrowed the amended registration and what would require, require a new registration, most specifically a transferring ownership would require a new registration. Any concerns or feedback on 18-207?
What about with upgrades to the property? Do you do it again then?
As written, there's no amended registration required. I hesitate when you use the word upgrades because if you're talking about permitted, well, for sure changes, but if I put in a new backsplash, I might not be letting the city know and I might consider that an upgrade. But when you talk about, let's say they've added a floor or added a stairwell or a wall, all of that, those kind of structure changes are going to be inspected as part of the permitting process. I don't know if that would necessarily trigger a new registration, but of course if you folks wish to say like the addition of a unit or something as triggering that, I imagine that if you're adding a unit to the property, you're wanting to, you may be, depending on what district you're in, wishing to get the occupancy that flow from that unit, you're going to need it inspected and approved in that regard too.
Otherwise, you're not compliant.
right, 18208 is duration of the rental registration. You folks have directed 1 year. I know there's other communities that do it every other year as sort of a administrative process. Ultimately, the current Senate bill that we've been referencing says 1 year is the absolute most frequent you can make it. You can't make it every 6 months or something like that. Nor am I suggesting that you've expressed a desire to do so, but that's the minimum is 1. If you wish to make that period longer, please let me know. Any changes there? All right. Next is just a very brief renewal provision. Each vacation rental owner has a duty to ensure he/she renews his or its registration annually prior to the expiration date of the previous vacation rental registration. Just sort of hey, it's on you to make sure you're current. We're not your property manager that way. The next is the inspection provision, 18210. It says to verify compliance with the Florida Building Code, fire and life safety codes applicable to the property, and to verify the interior and exterior plans that are submitted align. An inspection will be done. The city will endeavor to coordinate with the owner and complete the inspection process prior to the expiration of any existing registration period. However, only as to renewing applicants, if the availability causes a delay, there's some provision there. It also explicitly contemplates that we will do this in conjunction with a representative of the fire district servicing the city, and to the extent necessary, the building official or designated agent thereof. Presently, that's the county. Again, that's left open, so we're not going to change it just because if we change how our building, who our building official is, or how those services are rendered.
I think the chief wants to.
Yes.
No, sorry. Just had a
Speak
question
up.
to clarify.
Or the
Yes, ma'am. Just had a question to clarify the wording in 18210
Yes, sir.
for Randy. It says to verify compliance with the Florida Building Code, fire and life safety codes. But I'd like it to be a little bit more specific to say the Florida Fire Prevention Code, latest adopted edition. And the Florida Fire Prevention Code encompasses NFPA 1, NFPA 101, and any amendments to those
Understood.
those codes. So the Florida Fire Prevention Code, you could use that encompasses those 3 things. And we always want to use the latest
Yes, sir.
adopted edition. And then I had a question on how, we want to make sure that for the owners that we make it as simple as possible for them. And it says in here that when they do their application, they have to provide proof that they have had their inspections done and things. And I just want to make sure that we spell it out so that it's easier however we work it out together. We want to make sure it's almost like one-stop shop, right? Where they need to do their application or registration, get their inspections done, and that we're coordinated with you, so they're not making another phone call or another inspection where we could do it all together. But to spell it in there that they would need to have their completed inspection in order to get their application approved.
So sort of reiterating the point that a completed vacation rental registration shall not be approved until the subject property or unit is completed and passed the inspection process. That's explicitly stated above. You want that restated. You're suggesting that be restated within 18210. I just want to make sure I'm understanding what you're suggesting.
I see what you're saying. Yeah, if that could spell out separately from the inspections that the city requires, spell out the annual life safety inspection.
Now I understand you better. Thank you. Making sure the life safety is specifically called out as part of that.
Right.
Okay. Does anybody on the commission have any concerns with the chief's suggested or requested revisions relating to the language of the Florida Fire Prevention Code in its latest adopted edition, specifically calling out the Fire Life Safety Code inspection as part of that process?
No, I think it's a good idea. It's a good addition.
Ready, okay? Okay, good.
All right, that's consensus approval on that. Any other concerns within the inspection provision 18210? Next provision is 18211. Specifically acknowledges that when title to a registered vacation rental is transferred, due to sale or otherwise, the new owner shall file a new registration application. Basically, there's a new owner, it's got to change. There's no, you don't automatically inherit that license. You've got to submit. The next is more of a legal pronouncement as to vested rights. The section subsequent to that is 18.213, rendering it a violation to knowingly provide false or misleading information in connection with this process. The next is on advertising. There was some feedback on this. I want to make sure you're clear about what this presently says. No vacation rental may be advertised as an event venue for gatherings likely or intended to draw attendance in excess of the permissible occupancy and parking restrictions on the property, such as weddings, corporate retreats, or film productions. So not advertising in a way that says, perfect for your ... expected to, draw that occupancy. Some of the citizen feedback you've received in the interim is, and we talked about the potential need to harmonize these things, but you do have Greg, I always get it wrong, I think it's temporary use permit, is that right? Some people have referred to it as a special event permit, where if you intend to have a gathering in excess of 50 persons, you need to get a temporary use permit. Below that, as a property owner, not necessarily. And so there was some concern in citizen feedback that, as written, they're subject to all the same provisions as any other residential property is, and so that would be the same applicable provision. The other consistency with the rental registration, having that sort of that language there posted, and then advertising violations, that any advertisements that don't contain that averment, also, that it's a violation not to have that. Again, there are some, in Senate Bill 714, there are some provisions that, depending on how it's phrased, and I'm monitoring, tracking, and looking at committees to determine whether they're characterizing that as an preemption, because there's some language about what DVPR can say about advertisements and hosting platforms and what their content is. But thus far, again, this is the language we would require. Any questions there? Or concerns within 18.214?
What happens if you advertise that it's good for gatherings?
It would be a violation of this code, which would be submitted to the magistrate for adjudication. Or they would just come into compliance upon being noticed that, hey, you can't do that. Oh, I didn't know, or fine, I'll fix it. Our goal through the code process is compliance. That is what code enforcement is about, is compliance. So it would be an attempt to achieve compliance with that for prosecution. The next section, absent any feedback, we're on page 14 of 23. Is section 18.215, the duties of the vacation rental owner and responsible person. This was another area where I think some substantive restructuring and revision did occur. One of the more repeated points of feedback and public comment, and to some extent on this dais as well, was the number of designated responsible persons and the practical limitations of availability. So this contemplates that instead of having up to one, you can have up to two responsible persons in addition to the property owner, and what their availability must be, and the response time is to be responsive within an hour of notice, and it is a rebuttable presumption of a violation as against the owner and the primary designated responsible person jointly and severally in the event of a complaint or event where the city is unable to reach or secure a response from the owner in the set time period. You can rebut that. In the law, rebuttable presumption is this happened unless you can establish otherwise to the satisfaction of elements we provided. And so you can rebut that of unanticipated exigency. Yes, I'm the designated responsible person. I had a family member have a cardiac event during that same hour. It wasn't neglect. It was, happenstance, for example. Unanticipated exigency, an act of God, we got a hurricane, or what have you, flood, or other exceptional circumstances justifying the unavailability of each identified responsible person, notwithstanding measures taken to ensure compliance. I didn't know that AT&T's network would be down due to some cataclysmic event. My phone was at the ready, I couldn't control it. Those sorts of things. So the next is serve, just as provides that we can serve notices on the responsible person for purpose of reading the property owner, subject, of course, to any other legal notice requirements. So that is the responsible person portion. This duties of vacation rental owner is a little more, between 18 and 216 and 215, there's a bit there, so I want to take it in segments. Any concerns, feedback, proposed revisions concerning the responsible person, it's sub A of 18-215. Okay, seeing none? The next is interior posting. The owner or responsible person shall provide the city and conspicuously post on the interior surface front door who the responsible person is. And there is another section that mostly consolidates postings, but I didn't want that reiterated under the responsible person portion. Again, the response time is set forth there again. Redesignation, legal duties, just kind of again reiterating what the job means and what you're volunteering or serving for as a designated responsible person. Any other questions, concerns, revisions within 18250? Okay, we're moving right along. We're on page 15 of 23. Maximum occupancy based on site capacity limitations. This, of course, was a substantive portion of our discussion last time. I attempted it to the best of my ability to synthesize the feedback you've given. And it provides that the maximum overnight occupancy of vacation rental units shall be stated in the form and shall be limited as follows. There is a sub 1 there that applies to the CT district. Ms. Hausberg, just as last time, I apologize for not having removed it yet. But given your feedback at this point, that sub 1 would fall away from this draft. So you're left with sub 2, which would become 1. In all other zoning districts within the city, so we would say, I would call out the districts within which this applies. The maximum overnight occupancy shall be limited to 2 persons per bedroom, plus 2 additional persons may sleep in a common area. Regardless of the number of bedrooms in or on the property, the overnight occupancy shall not exceed a maximum number of, and there is a typo there, of 12 and 10, and I think that was a function of transposing things, but it should be 10 in 18-216 sub 2. The initial, and that's I think just the 1 and 2 copy and then clearing it. It should be 10. That was the consensus direction of the body. 10 overnight occupants for the residential districts in which this will apply. So even if you have a 6-bedroom or a 5-bedroom with the 2 plus the sleeper, you're capped at 10 in this draft, and that was based on the direction given by this body. Is there anybody wishing to revisit or address that?
I'm not wild about that, but I'm just one person here. It just seems, as you said, if you've got a 6-bedroom house, to cap it at 10, it just seems a little counterintuitive. And I'm not sure what the rationale would be to cap it. And again, this goes back to something that somebody brought up before about square feet being perhaps a factor in this, but if you've got a house with 6 bedrooms, it's presumably large, it's probably got a living room. I mean, that's, I don't know, the 10 just, despite the fact that 10 is a lot of people in the residential neighborhood, given that, I still think that if you've been allowed to build a house with 8 bedrooms, capping it at 10 is a little, as I said, a little counterintuitive.
All right, and I want to be clear that occupancy, just in case there's any misapprehension, that occupancy limit applies only for operation as a short-term rental. If you plan to live there as a single-family home, that occupancy limit does not apply to your occupancy limit. It is for the rental purpose. Just because I've seen some misunderstandings in the circulated feedback. The other thing I would note, again, and we would have to revise to remove the reference to the CT. One of the other things that you provided was, for the year after this takes effect, they can have 12 and sort of slowly get the benefit of that, and then after that year, throttle down to the 10 number. So that is still within this, and that's in the vesting provision appearing on page 16. When we went through this draft the last time, sub C, the owner-occupied exception, when we were there, you folks said, I don't think we need an owner-occupied exception. But then by the end, when we got to the affidavit that exists to substantiate that, there was a revisiting of that notion and a general, it was split, but a consensus, an agreement of majority to reestablish or to maintain an owner-occupied exception. So that's why that language is here now, should you recall, oh, I thought we took that out, well, we did, and then we sort of revisited the notion thereafter. And so that's a hat tip to that. The next provision is 18.217, minimum safety and operational requirements and limitations. This is another place where, while the content is largely the same, the layout changed. Again, we had two sections that had required postings. And to avoid, acknowledging some of the chief's feedback, we wanted it as clear as possible so people are looking in one place. And so the feedback here, first, the safety codes apply. That doesn't change. Quiet hours limitation, it has no persons other than the occupants who rented would remain under on the property between quiet time hours. Outdoor amenities was another point of feedback that you've given about no pool, spa, jacuzzi, or outdoor sports courts on the property may be used by any guest or occupant between those quiet hours, and then the amplified sound restrictions. So that is there any feedback on that particular portion or any specific concerns you wish to have addressed? Just on the quiet hours limitation portion.
Captain Liner, I was just going to ask you about the parking and the noise and do you see any limitations or enforcement issues? What are your thoughts on that, specifically to this?
So I just look for clarification. Can you hear me? Clarification on it. Is it working? Let's try this again. How's that? I'll just yell. So I just look for clarification on it. So these three, this 1, 2, and 3 applies to vacation rentals only, correct? Is my
It
reading?
says the following restrictions shall apply when a property or unit is in use as a vacation rental.
I get it.
Yeah, so it is for vacation rentals only. So the fact that, and I want to make sure I'm clear on this too, what's intended by that language is a vacation rental is defined for purposes of this ordinance and statute by at least 3 rentals of less than 30 days in a year period. So let's say you are functionally a snowbird, but you're gone in the summer months, and so you rent your property from, let's say, May to August in that interval, but you're living there in September, October, November. That provision as written there doesn't apply during that time. However, the amplified sound restriction is coextensive with the language appearing in our noise code. So B sub 3 is the same language you'll find in our noise code about amplified sound. 1 and 2 would really be the changing factor there.
And I apologize, I did read on that. I did actually catch one yesterday. So like if the homeowner is there, it's not applicable, but if they're renting it, that's where it applies. Obviously on my side, I'm just trying to get the clarity of what the council wants on that. With something of this magnitude, I would report this back to see operationally how we're gonna handle this. So I just wanted to be, what I'm here for is to make sure I'm clear on what you all want. So this time, what do we call it? Quiet time, 1 and 2 are exclusive for properties being used for potential rentals. So in theory, I guess my question I'm asking, you could have somebody at this property, we send the deputies out, that's in the jacuzzi at 10:05 at night, that's in violation of this, but someone next door that's not a vacation rental wouldn't necessarily be.
As written, yes, that was the consensus direction of this body. Of course, we welcome your feedback on this. I think that ultimately I'll leave that to the policymakers to discuss.
And like I said, I'm just looking once I leave here because obviously something of this magnitude, I'm not going to be the one making this decision on this. Obviously, it's a huge impact on the community. So I want to make sure I'm clear, and then I'll report back to my boss to say, hey, this is, I clarified, this is what they want, and then we'll get you, I know you got a timetable, we'll get you a response ASAP.
And without putting any words in either Chief Liner or Deputy Liner or the Sheriff's mouths, I would say, from a practical standpoint, I will tell you that you're likely to see enforcement of these provisions aligning more with noise and sound than your deputies acting as hotel concierge telling people to go inside. And that's not direction he's given me. He didn't tell me to say that. I'm just telling you in my experience of watching how these kinds of things get administered, that's usually how they get administered. And I would tell you that if you have language that you're just sort of, in any part of this ordinance, and I'll draw back from the provision we're discussing. If it's impractical for you to administer, you don't think, well, we're not actually going to enforce it that way, then just take it out. Because it puts your folks, your enforcement folks, whether they're your deputies, your code inspectors, your managers, in a tough position. And I'm not advocating for any version of this ordinance. I'm just telling you, if you're thinking like, oh, well, no harm, no foul, it just probably won't be enforced, but at least it's in there, that's not a good way to write code, generally speaking, because it puts your administrative, the sort of separation of powers, it puts your executive branch in a rough position. Because they're still going to get called by the neighbors saying, oh, I sat through all the workshops, I saw it adopted, I called the sheriff and he said, well, they're being pretty quiet back there, and I just told them, please keep it down, but they're still out there. And I'm not, again, the sheriff's office has made it very clear, they've not taken a position, they'll take it back and determine, and they are contracted with us, we have policy positions, but I will tell you from a practical standpoint, that's more likely how that will be enforced.
I understand there's a lot of concern about late night pool noise, jacuzzi noise, that sort of thing. Is that stuff that can be resolved with current noise ordinances?
I believe
Sorry.
you still have the loud and ruckus and all that.
We still have the loud and reckless. We still have the decibel readings in our noise ordinance. Yes, those will apply equally. Those are still of application. The short answer to your question is yes.
The only thing I would say on that is operationally there's a difference between kids in the pool, say at 5 o'clock p.m. versus kids in the pool like midnight or something. So it's along the lines when you talk about taking everything into account. But obviously it's there and we've dealt with stuff like that. And then we're actually doing some sound meter training because that takes the subjectivity out of it. It really doesn't apply to like people talking and playing. It's more like a noise type, like a music type thing. So I know we've got that in the plans to get some more people trained, so we have to use that. We can apply that. But even if we don't have that, like Randy's talking about, we still have a lot of ruckus standard that we can apply without that.
Joe, any comments?
They were just saying I know what we're trying to accomplish here. Is it practical? And if I'm causing the ruckus, per se, which I probably have.
Yes, you have.
I have.
I've been there with you.
Could be. In my opinion, how's that different? We all have a good time in Indian Rocks Beach. It's an enforcement provision that's going to be a struggle.
I don't want to have pool police. I really don't. I don't like the idea of pool police. I can see you hanging on a fence, looking over who's in there, and get out now, and it just sounds crazy. It just sounds nutty. And something that's going to be impossible for you to enforce because they're going to hide from you, and you have to get up on the fence and look over again. It just seems fruitless.
What would the commission like to do
Just
with this?
to maintain the quiet hours.
I maintain the quiet hours, but I'd strike the part about the pool.
No pool
I have
song.
Since we have the noise ordinance, and just assure the deputies who have to file a call when they're on property to see if it in fact, what's the common man, intelligent man?
Reasonable person standard.
Person standard, okay. So they're the ones who are gonna have to make the call, so.
I'm not too keen on the access limitation one either, because like a dinner party will often go past 10 p.m. So, I would consider that to fall under the same header there.
Yeah.
And again, if we're talking about the practicality of it, again, not speaking for PCSO, but understanding, having worked with them very closely and officers in other jurisdictions, they're not going to be in a great position to determine who is an occupant and who is not. And say, I think you're lying to me, so I just add that as if you're thinking about it. Again, ultimately, if you folks want it in there, we'll figure it out. but I do want to make sure you're sensitized to some of those administrative or practical elements.
I mean, if the sound ordinances are all part of the registration and your, infractions, then it seems all folded in already. I don't see the need to overcomplicate it.
I would agree. All right. I believe I have consensus direction from the commission to strike within section 18217 sub B, striking 1 and 2, preserving the general amplified sound restriction, which by the way is taken directly from the current noise code and just restated here. We can leave that, and otherwise I can make sure, especially given that the removal of those elements, make sure if there's any other elements of the noise ordinance that they best be restated here, or that provision is cross-referenced explicitly. Okay. The next is required postings at the unit entrance. I actually made a distinction because within the previous draft, it was like, here's the things you need by the door, and here's things that have to just be somewhere else. And the way you've seen that typically is, for example, here's the stuff that's going to be within 5 feet of the exit or on that door, versus here's the stuff that's in a binder right by that door. And maybe we include some of the city stuff, and we also include nearby restaurants or whatever else we do, but here's the binder of resources if you need it. But we don't need to make the entire interior look like a billboard. And so the required postings are any owner's conduct rules, if they have them, occupancy limitation, the designated responsible party, as noted within the designated responsible party, the noise disturbances language to respect those quiet hours that we just talked about, and if there is a building evacuation, most notably in the storm scenario, understanding they have an obligation to evacuate, making that clear as we have guests who are unfamiliar, news coverage notwithstanding with what it is to be in those scenarios. And then the additional information that would be provided is the official street address and unit number, if applicable, because not every place is going to have a unit number. A copy of a document to be supplied by the city, which includes city codes and relevant things, just like we talked in the past, Commissioner Hausberg, where you helped provide, like, here's your cheat sheet on how things work here. Days and times of trash and recycling pickup, which may be a part of that document, but some of these may be coextensive. Maximum number of vehicles, phone and address of the nearby hospitals, emergency and non-emergency phone numbers for PCSO and the PSFRD, emergency evacuation instructions and routes, and finally that rip currents are prevalent in the Gulf of Mexico, and information about National Weather Service. So that's the additional information that would be provided. Any questions or concerns about that? Additions, deletions?
Greg, when a person comes in for a registration to register their property, do we give them the magnet that Denise, is that part of the package, or do we do that at this time?
No.
Could we do that?
Yeah, we're going to do that, and then if you recall, I think at the first or second work session we had, there was a thing that we picked up down in Holmes Beach. This little thing you put in there, such a little, not barcode, but the little scan that links you directly to the rule. We'll do that in addition to this required posting.
Just so the audience knows, Denise at one time made a 5x7 magnet that you can put on your refrigerator. It tells many of the codes, the hours, the noise, all different aspects of things that you need to know about the community. So I'd like to see that's put in when we do our registration.
Yeah, one thing I was sitting here thinking about is that, one of the complaints that we hear a good bit is the topic of golf carts. So I don't know if we need to, Randy, I was thinking about that. I don't know if we need a list on this official list or reference to that, in the handouts you're talking about, Mayor, that there's a reference in there to golf cart, just reminding people what the rules are. For example, if you have a licensed golf cart, you can drive a golf cart anywhere in town in Delgado Boulevard. If you're staying in one and it's not licensed, you can only drive it on the city streets and cross Delgado Boulevard to get to beach access. So I may talk to Randy a little more about this part of it. That's a common thing that we hear at City Hall frequently, so maybe want to clarify that around that.
And for the aficionados who've just been following the saga, The manager was referring to the difference between a low-speed vehicle and a golf cart and the different privileges and requirements around those. And that's called it in our ordinance. But Madam Mayor, I believe the deputy chief from the fire district had something else he wished to add.
In an effort to avoid duplication, the building evacuation line 5 is included in our life safety inspection, so that I would ask that you strike that number 5 from yours, if that's possible.
Well, if you're also requiring that posting, if the fire district will require that posting as part of its inspection, to me, that redundancy is not an issue. The fact that we're both requiring it, to me, doesn't present an issue. We may wish to add that as also required by PSFRD. If I'm understanding your question right, you're suggesting we're both going to require it. I just want to make sure I understand the concern.
Again, but my thing was,
They're not gonna be able to hear you.
you have the minimum size and all that stuff, like
Yes.
that's not spelled out in ours, so I didn't wanna make sure that one meets our requirements and the other one does not meet your requirements. So we either duplicate this language as stated in here, in ours, or it can be removed from yours, because it's already gonna be a requirement under the life safety inspection that we are requiring.
Understood, and we can work through that before we get to first reading. I don't know that needs to be resolved here in this moment. My concern is, you see where I have required postings, I talk about font size, font type, size, because what we want to avoid is malicious compliance in the form of, I put it in Wingdings in 6-point font, but it's there. You do this enough to try to anticipate too much, and perhaps that's too much, but we can talk through that draft and reconcile what you folks think is sensible, what might be standard based on your knowledge and experience in that area as well. If there's a size that's more commonly used in lodging establishments that you're accustomed to seeing, we can also align with that. But your point is well taken, and I'll flag that. Are there any other questions or concerns or feedback concerning the required or additional postings in 18-217? All right, seeing none, that takes us to parking, solid waste disposal, legal compliance, evacuations, and miscellaneous provisions. The first is parking. Parking was one of the points that, while we were able to move with relative ease through it, the general feedback that was given was we like the language from one of the sample ordinances that is a spot per bedroom. And so this draft tries to harmonize with that. And how this draft reads: for single and two-family dwellings, one on-site parking spot per each bedroom within each dwelling unit as designated through the vacation rental registration process. Perhaps of less import now that you've taken the CT district out of this, but for multi-family dwellings, it was 2 spots for 1 and 2 bedrooms, and then 1 per bedroom for every bedroom over 3. Whereas in your land development code, as noted in the materials provided to you by the manager before this meeting, your land development code, in terms of what they have to put in a multifamily, is for 3 bedrooms and above, it's just 3 spaces. So whether you have 3 bedrooms, 4 bedrooms, or 5 in a multifamily, it's just 3 spaces. I think of less import, and I'll defer to your manager who's more familiar with the lay of the land, but I wanted to be clear that as written, this is actually requires more parking than the land development code requires when developing a structure of this nature. And with that, Greg, is there anything you want to add to that?
No, you covered it. I just want to make sure that y'all are aware that based on the draft compared to the current ordinance that we have, that particularly on multifamily, would be allowed in the OD ordinance of multifamily on the east side. Property that's zoned that would allow multifamily is that right now the land development code for 3 bedroom or more, like Andy said, is 3 spaces. So the way this draft is written is for 3 or more, it's 1 space for bedrooms. There's a difference there. So, and that's like Randy's illustrated there, again, strictly how you want to do it. I did want you to understand that I handed you the little sheet, the differences between the land code and what this draft says.
Is that clear?
But they need to be in agreement, or should they not be in agreement?
Well, I talked to Hetty Harmon about that today. Hetty, for the benefit of the public, is our our plants, city planner, contract city planner. And, if you think about the most intense residential use that you can have, which is multifamily, and 3 bedrooms or more is capped at 3 spaces. I asked her about that, we talked through it. And the logic behind that is that there's an assumption that in multifamily, that not everybody's gonna have a car. So, so therefore, that's why it's capped at 3. Cause like with vacation rentals, a lot of people that go to vacation rentals, we see them all the time. You'll see them out in Gulf Boulevard with their luggage. They're getting here by Uber or they jump buses from spot to spot. So I think, that's why zoning ordinance and land development regulations like ours take things like that into consideration where it's just not every single property. You just say if you have a 4-bedroom multifamily condo apartment, so the logic that not everybody in that 4 bedrooms is gonna have a car. That's why it's capped at 3.
And the other reality that I want to make you folks aware of, again, the draft exists. I looked to the LDC and Greg and I were specifically cognizant of that difference between the LDC. This draft was based on your consensus direction. One of the other issues you may have is to the extent some of those multifamily properties are built out to the dimensions of the lot, parking and otherwise, there may not be space for a 4th or 5th spot. And we can talk about how we reconcile or address that, but I do want to make sure you are aware that it's my understanding, and I'm not independently aware of a specific address, and the lawyer doesn't get on that side of things, but I want to make sure you're aware that that potential could exist, where, hey, it's a 4-bedroom, we built out 3, all there's space for is a mailbox and where we put the trash, there's nowhere else there's no lawn, great big lawn to speak of.
Is there a benefit to requiring more parking?
Well, the policy discussion that was had last time centered around trying to mitigate the amount of excess parking that may, as a function of this particular use, flow into congest or otherwise obscure street access.
Mm-hmm.
That was at least some of the policy direction that was discussed. Ultimately, again, whether or not there's a benefit is for you folks to determine.
I'm wondering if maybe that can't be addressed in some other way.
You let me know.
Yeah, Sunday.
One other comment I make, because this was discussed at the last meeting, and Hetty and I talked about this today, is that anywhere in the city where there's required parking, the approval process that would come through the city was wherever the required parking is, it has to basically be on a hard surface. It has to be on shell, concrete, pavers, or asphalt. In other words, whatever you make the requirement, whatever the requirement is, 3, 4, 10, whatever it is that when they go through the approval process to get their required parking approved, do they just keep parking in dirt, grass? I've seen some emails from people saying, well, if you mandate parking, they're just gonna immediately start parking on grass. That's not gonna meet the ordinance that we have. So I just wanted to really put that out there that whatever required parking we have in the city, it has to be on a surface. And now, I mentioned this the last meeting, but I'll mention it again just for the sake of the record, is that in the single family districts that we have, there's no drainage requirements, which I'll tell you is highly unusual. Something probably we should talk about later. The one thing that Hetty does when she reviews a site plan for something in single family, there's not drainage requirements, but she looks at the slope of the property, and she does her best to, before she signs off on a project, to make sure that when new construction happens in a residential district, that at least the water that they're gonna run off the property does not run off on a abutting property. The downside for the city is, then what that means is all the water is gonna run off in the street. And then we wind up dealing with, we just did the updated stormwater plan, so all that factors into it. But I just wanted to say for the record, because there was some discussion back and forth, and I've seen a couple of emails about, well, if you make this have 2 parking spaces or 4, whatever the number, people are just gonna park in the grass. No, they're not, because they would have to have an improved surface to do that. And my only other comment that I made previous to work sessions is, sometimes you get to, think about what you're asking for, because particularly in residential areas that we're all sensitive to, and the changes in residential areas, if you're too stringent on parking requirements, you'll further alter the appearance and feel and look of the property, because if you go too far with that, they're like anybody else, they've only got a certain spot to put the required parking, which is in the hard surface, and I think we all know where that's going. It's going in the front yard, side yard, but just particularly want to address that there are requirements for parking, and you just can't park for the required parking space. You just can't park on that grass.
Okay.
Is anyone feeling there's a benefit to having enhanced parking requirements per bedroom other than what's required currently already? I mean, I know that there's a goal, but is this the way to get there? Since we're on talk. I mean, I'm not sure what the benefit of adding the extra required spots would be, particularly as Greg was saying, if we're gonna have every one of these short-term rental properties is gonna start paving their front yards. So, which of course is also going to increase runoff. So.
We worked 18 months on the parking ordinance.
Was before me.
Well, maybe what we should do is get you a copy of it.
Greg was being surprised. I actually have one thing. Doesn't mean I agree.
Well, I mean, and just to read it over, I don't mean that to be malicious or anything like that.
I have.
What is, any comments from the rest of the commission?
We probably just revert back to the land development code on the parking, 2 spaces for single family duplex, and for multifamily, 2 spaces for 2-bedroom, and 3 spaces for 3 or more.
If I'm not mistaken, if people come in with more cars than fit there, they simply won't have a place to put them.
They park them on the street. And that's what we were trying to reduce.
Yeah. No,
But I don't know if we can. Jeff? Because I know parking on the streets is a problem for Jeff too.
Well, for everybody. So, I mean, we don't want them parking on the streets. We don't want them parking on grass. We don't want water on
We don't want them to bring
cement.
cars. We don't want them to bring cars.
Yeah, we want the right number of cars for the size of the house.
That's right. Yeah.
Well, we continue to evaluate streets that are having issues, am I correct, Craig? We have a list, and
We're through evaluating streets. Yeah, we're obviously always open to complaints that we receive. But I know what year it was several years ago, we went through the exercise and had work sessions about the beach and beach parking, and as a result, Fort Dean has installed probably several hundred no parking signs, and we get very few complaints now about regular routine parking. But we have gotten complaints on a handful of properties about, a vacation rental that's got 4 or 5 bedrooms, and they wind up in the afternoons with, like 15 cars out in front, or 15 cars in the driveway, and, but the no parking areas are really from, if you think about the map of the city, it's really from like Bay Boulevard over to Gulf Boulevard, kind of that width all the way down, and that's worked pretty well for us. And then the cul-de-sacs, most of the cul-de-sacs now, there may be 1 or 2 that we've not been missing, because the chief, Jeffrey, or the previous chief, sent me an email, and most of the cul-de-sacs now are no parking. There may be 1 or 2 that are not, because that's where the concern was. You get to the end of the street, you can't make the turn on the cul-de-sac. There's gonna be a couple times a year, New Year's Eve, particularly boat parade nights, where people are just parked all over, but that's an exception. But we don't, other than the complaints that we get the handful of complaints that we get with, really like probably 8 or 10 larger vacation rentals, we don't get a lot of parking complaints. One of the things that we did prior to even the first work session in the fall, we probably implemented this a couple of years ago, is that just to limit where people are parking throughout the town, there was an existing provision in the city code that said that you couldn't block a mailbox. In the direction I gave our code people, the sheriff, they may handle it differently. When our code people are out there, we have 2 code people, so we have the 2 guys out 7 days a week. The instruction that they've been given is that basically if they're on a city street and there's a vehicle parked on a street where a postal truck cannot access the mailbox that's about a car length or a little more, you're gonna get cited for that. And that's helped us because the word's gotten out. So if you think about it, the point I'm making about that, if you think about a city street and where mailboxes are, and this is not in the current ordinance, the current vacation rental ordinance, it's in the city code. So it's been there for years, is that if you can't block a mailbox, it really limits where you park on the street, because there's mailboxes in front of every lot. And you've got some space there. That's one of the houses that we've had some trouble with, on a Friday afternoon and then turn it into a Saturday event, is that for the same property. That was just one property, and this is not a widespread thing. I think for the same property, Frank, one of the code people, for a 2-day period, but like 8 parking tickets from the same house, because they can't block in the mailbox, block in the driveway. But that's the exception. We don't get on it. I know you asked me a question, but I was thought it was important to kind of explain what we do.
So where we stand at this point, which so far I think Member Housebird's been very clear that the parking restrictions, in as much as they exist, should be in alignment with the current language within the Land Development Code for the LDC. I welcome the remaining members' feedback so I can be clear on what the consensus direction is.
So is the conflict in the multifamily or the single family, or both?
Principally in the multifamily. So a single family, it's in both, because the way the single family and 2-family dwellings read, under the current code, it's, if you have a single family, it's 2 spaces. Here we're saying it's 1 on-site parking space per each bedroom, which can get you beyond 2. This provision, however, does explicitly contemplate that available garage space is part of that count.
Right.
And then to the extent it's multifamily, which can exist within the districts that are still being regulated, that's where the biggest conflict is, because under the Land Development Code, the LDC, it's capped at 3, whereas here it has a 1-to-1 relationship to the number of bedrooms. So that's where, to the extent there's a disparity, that's the biggest one.
Okay. I don't have a problem with the space per bedroom personally. You got a 3-bedroom house, even on some of our small beach houses, 3-2, there's going to be a garage plus 2 on a single drive. That's easy to fit 3 cars. I would expect 4-bedroom or 5-bedroom home to have at least a dual-wide driveway plus garage. That, in my mind, would not be tough to fit 5 cars in that. I think the vacation rentals actually present a different opportunity than a family, right? You may have both parents that have both cars, maybe a toy. But bottom line, if I got 4 people coming for a 4-bedroom or 5 people coming for a 4-bedroom, if they're couples or this, that, or the other, they're bringing a car for the most part. Can't say absolutes, but I don't have a problem with the way it's written. I think that creates more cars, that those homes should have that, and it really shouldn't be that much of a compliance issue. As far as the multifamily, it's minimal. That could be something that we do to the land use code, because bottom line, multifamilies are going to create a separate parking issue, right? Just because of, like you said, they're built to the end, right? You can park underneath. It depends their development. That I can see with multiple bedrooms having a harder time complying. But as far as the single family, I think most houses could work that in without paving their front yard. Maybe widening their drive at most. Just my opinion.
Any more comments? Are we good with what's?
Are we gonna catch on fire, Joe, when people start paving their front yards?
What are we agreeing to here?
Well, so far, Member Hausberg has said she preferred to see this provision harmonized to the LDC. Member McCall says he thinks it's generally fine, though recognizing there may be potential limits for certain properties which can be addressed through special exceptions or otherwise, quite honestly. But I don't have consensus direction from the remaining three members.
I mean, bottom line, we can't stop that now. If you want to paver your front yard,
But requiring people
well within
to do
your
it is different.
right to do so. Whether you
Requiring
live here,
to do it is
That's
Be
my
upset
only
if I had to
concern, is
pave my
requiring the additional parking spaces, and then people go crazy with getting concrete in their front yard, and then changing the look and feel of the whole neighborhood.
great. But you did just put an occupancy limit, right? So the 20 cars showing up, and that we've had a problem with. You know, that we've put that limitation in, so that should push down on that parking piece, in my opinion.
Mayor.
Yes.
Greg, directed to you, if somebody were going to go in or was going to go in and pave their parking in their yard, for example, isn't there an impervious thing as far as
Thank
water
you,
draining and so
Bill.
forth? You know?
In the single family district, that's, you know, brought that up in every work system we have. In our single family district, which is the majority of the area in question, there's no drainage requirements. All the water is dumped in the street. And that's what I was saying earlier, what Hetty does out of courtesy to
Yeah.
neighbors, is try to make it from going on the neighbors, but it all runs out on the street.
Okay, thanks.
Member Hannah, do you have any, since you're the last to speak, do you have any direction on which parking arrangement you prefer, whether it be the LDC as is or some other version?
Well, I'm kind of mixed. I agree with the consistency of the RDC, but equally, half the problem I have, there is just so many cars on our roads right now. And with that, I probably go more LDC than one group, but I'm okay either way.
Madam Mayor,
Yes, sir.
if I could ask.
Yes.
I'm sorry, I'm not very used to working with microphones.
I'm not used to it, so I gotta yell.
Captain.
So you can hear me?
Yes, sir.
Okay. I just wanna make sure on the expectation side of all this again. On, I guess it's page 19, the permissible parking locations. I get obviously why you're all doing this and stuff, but I'm just trying to think what the expectations are of us. Do you expect, say somebody calls, typically this would be at night because they're causing more noise type deal. So if they call and there's 10 cars on the street, is the expectation of us to go out and identify who those 10 cars belong to, and then if one of them was a rental, like I would assume somebody tell us like these cars pulled up and a couple went into that house. Okay, we can start there, but we verify the other cars, and then if they're in violation, we're looking at an ordinance violation for, I guess, the owner or the whatever. I'm just trying to figure out what you expect us to do on, so I can tell the deputies, obviously. That makes sense.
Only if they're blocking the mailbox.
So, and I guess the parking for us, that's easy because obviously you see you're parking in front of a mailbox.
Yeah.
And I get what Greg was saying, obviously, about parking on concrete. I'm just trying to make it so I can give the direction to the deputies, and they're doing what y'all want.
Well, I would like to just interject so there's some understanding here. What we're talking about has two components to it, right? Because part of this is the minimum required parking as part of the vacation rental registration process, right? So what your folks are legislating here is, in order to legitimately operate, lawfully operate a short-term rental in the city of Indian Rocks Beach, what is the minimum parking requirement for your property to get signed off and approved? That's what's here. Now, if somebody's parking unlawfully, that's unto itself sort of an over and above element. But what we're trying to most specifically address here is, when they come to sign up, they need to show us that they planned accordingly, right? And planned accordingly, part of it is all the required postings and all of that. One element of this, going back to the vacation rental registration submission, included an application with different contents, an exterior site plan, an interior site plan. Another element of that was your parking plan. And so what they need to know is, well, if I'm submitting a parking plan, how do I know if my parking plan is in compliance before I submit it? I don't want it to, we don't wish for it as a city to be arbitrary. We want to make sure that it's clear what's expected of an applicant. And so in this context, having what the requirement is, when you submit your parking plan, we expect you to show us X. And Commissioner Hausberg has said, I expect it to conform to the LPC. Commissioner McCall says, I like the language there. Commissioner Hannes could be persuaded either way, and so at this point I'm still looking for consensus direction from the body. How about you, Madam Mayor? Okay, so following that conversation, the minimum required parking for a vacation rental will conform to the minimum required parking for the structure based on that requirement already existing in the LDC. That's how that would be in the next draft. And of course, this is still part of the legislative process. If for some reason you revisit that on first reading or beforehand, of course this remains ongoing. The permissible parking locations, I think, would still conform, subject to making sure that is consistent with the LDCL, and I'll work with the planner to make sure if they don't count garage spaces or whatever, that we address accordingly. The next provision is solid waste disposal, which just says you got to abide by whatever your trash day is. The next is just you still have to abide by the law while you're there. Again, evacuation, underscoring again that vacation rental occupants are required to participate in all mandatory evacuations. The last is the temporary use permit. We talked about that for a little while during the last one, that if you're the owner of a property that has a rental registration, you can apply, but it's unlawful for you to apply on behalf of a guest or a tenant. It's for your use, not for not for short-term rentals to come in and have those temporary use permissions. We address storage, and we address the limitations on permissible rental. I believe this was in the last draft, the sub G to 18-218. There was some comment made that it was not addressed. I want to just read the language in case there's any misapprehension. No accessory structure, shed or an outbuilding, vehicle, recreational vehicle, trailer, camper, boat, yacht, or similar apparatus shall be utilized or rented as a vacation rental or used to impermissibly provide sleeping quarters or otherwise accommodate more than the permitted number of overnight occupants on a property when used as a vacation rental. So if you get 10 occupants, it's not 10 plus whatever you shove in the RV. It's 10 occupants. And I do believe there was some revision of that language to bolster that second element, but that language exists there. Are there any other questions within 18-218? Okay, 18-219, I know there was some public feedback, and I believe even some commissioner inquiry following the circulated draft. This language did exist in the past, and what I want to make very clear is this does not prevent you from saying in your listing that you have a pool, or you have a recording studio, or you have a tennis court. What this specifically prevents is marketing and renting that separate from the entirety of the structure. And that language exists there in that last clause, or otherwise renting or leasing individual amenities, features, or accessory buildings or structures on the property, separate or apart from the primary structure. There are platforms that exist for functionally carving up your property into rentable elements. This seeks to avoid that. Similar language has been adopted in other communities in Pinellas and in the state addressing that phenomenon. And so that's what that aims to do. This is not saying you can't acknowledge the actual design and structure of your property, just that you can't rent out individual elements. You're renting out the property. Any questions, comments, concerns?
So what you're saying is like, you can't, like, if I got a boat slip, I can't say, hey, bring your boat, your friends can stay on the boat.
No, what I'm saying here is actually a little different from that. I don't plan to rent my home, but I'm happy to rent my pool for 2 hours.
Oh.
That side,
Okay.
taking an individual amenity and carving it off in the property, or I'm willing to rent out my backyard for birthday parties. I'll be in the house. You guys have no use of the house.
Okay.
You're only renting out the backyard.
Okay.
Or something of that sort. This seeks to make it so you have to have the rental fee for the primary structure, not for individual elements on the property.
I have a question about that. As far as often, of course, in Airbnbs, people rent out just part of the structure, or one room, or say a wing, or the mother-in-law cottage. In the case of, say, a mother-in-law cottage, how would that be affected?
Well, there, what you're looking at most more likely than not is an owner-occupied rental. I'm occupying the house. You can have the out parcel or the outbuilding. In that case, as drafted, there's an owner-occupied exception that carves that out. So that's how that would handle that. And you could still, and the same true usually if you're just renting a room. It's owner. I have this part of the house. You guys get the room in the back left corner. So that's how that's handled.
What about two separate, for example, Airbnb rentals, one for the main house, one for the mother-in-law?
That would not be permitted. You would have, the way it would operate is there's one rental of that property. You are renting out the house, not the accessory structure.
How do you guys feel about that?
I like it.
You know, there's that app where you can rent out your pool by the hour, actually.
This language is designed with that.
That's
Not a particular platform in mind, but with that phenomenon in general. That is precisely what it's seeking to address. If that's not something this community wishes to address, by all means, let me know. We'll take it out. It's up to you folks. I give you resources. You tell me what you need. All right, the consensus direction is to maintain the language as is there. 18-220, minimum life safety requirements. And again, for the benefit of Deputy Chief and Chief, in the interest of getting this out, I did not run, just full disclosure to all present, I didn't specifically run this language by Chief. Of course, we're here now, and as we continue to harmonize other provisions, if there's any term of art that I've used that doesn't align with, I'm requiring something over and above what is commonly required. Chief, early on in the process, gave me some feedback on the kinds of extinguishers that would or would not be required and the like, and I tried to harmonize to that. But generally speaking, this is to call out and I'm forgetting the term you used earlier, but the life safety codes, the fire prevention code in its current iteration sort of requirements. And that's what's intended to be recognized here. And so where you see things like exit signage, fire extinguisher, carbon monoxide, and battery-powered emergency lighting, all of that was based on what PSFRD, the general direction I understood PSFRD going. It is not the intention of this draft to go over and above that and require things that they're not. So, Chief, is there anything else you wish to add to that, having reviewed it?
No, I think you hit everything, and again, we're going to be rolling out this program. It's going to tax our inspection personnel. We're going to actually have to add a person down the road when we can, but we're looking to work with the owners and the residents to do is to make sure everything's as simple. We'll have some checklists spelled out for them ahead of time. Here are the things that you need. We'll be able to assist in any way possible and try to make it as easy as possible for them.
And it's drafted this way. There is another way to do this where you could just say, well, we're doing whatever they're doing. The concern there is, again, communicating those clear expectations. While there may be an over and above, and perhaps we add language saying with PSFRD, as the city's contracted fire department may or establish whatever the language is, may require and shall be compliant with that as well. That edit may be well placed, but I think it's better to have some of those clear expectations to the extent they're knowable enumerated here, and so that's what that does. Any questions or concerns on that provision?
I got one additional thing.
Yes, sir.
69A-43 outlines the Florida Fire Prevention Code minimum life safety requirements for
What is it again, 69?
69A-43. are you familiar with that one? I don't know if we might.
Old classic, love that one.
But some like, I don't know if that should be referenced in there. Again, if they modify that document, or do we need to make reference to 69A43 in there, because they've already set some minimum standards to which these.
And so, and again, I think this is another one of those inside baseball moments where we can, resolve that on the back end to either determine what those requirements presently are, or acknowledge that provision, and based on what our draft is and what the direction yours is moving in, harmonize those. But we can look to the Florida Fire Prevention Code's contents in 69A-43 and make sure we're consistent with those to be sure.
Okay, we're good.
All right. 18-221, and for those following along or just wanting to know when will you stop talking, we are on page 21 of 23. Exemption for pre-existing rental agreements. I think there was some misunderstanding about what this language does and does not do. Once this ordinance is adopted, it will have an effective date, and it will apply to all rentals within whatever districts you determine that it will apply to after your second reading. It will apply effective that date, and it will set forth the timelines for coming into compliance and applying and all of that. If a party is presently operating a vacation rental within a district where this is applying, they are not exempted from this. There's no grandfathering out. This isn't an opt-out thing. And we're not requiring any, beyond the fire safety and pool safety requirements, we're not requiring structural modifications substantially. Here, we're requiring principally registration, accountability, and in the other end, and required postings and the like. So there's no, this exemption is not, if you're renting now, it's not going to apply. The exemption is for the provisions of this article to the extent any newly adopted term of this article conflicts with the term of a pre-existing agreement entered into before its adoption. So let's say, and I'm not establishing a timeline, you're not putting me on dates. Let's say this is adopted May 15th or June 1st. Let's go June 1st. But I right now am a super responsible person who's already booked my stay in December of this year, and I'm going to be in excess of I'm going to have 14 instead of the 12 that I'm going to have for this one year. Well, then that I can say, like, yes, I legitimately do have 14 guests, but that was entered into before your provision. We're not trying to interfere with contracts that were entered into before the adoption of this ordinance. That's all this does. This is not a safe harbor provision such that if you were operating and by the way, it requires you to have been lawfully operating prior to that under our criminal code. You can't just pop up and say, oh, I've been renting for 2 years. Well, you weren't registered for 2 years. So that's a problem in itself. And it goes into how you would establish, it might be that you get cited for an ordinance violation based on, hey, you were in violation, but your defense is, here's the proof that this was booked in April, and you didn't adopt it till June, you have this provision, there's some of the elements, copy of deposit, copy of email, information from the occupant confirming that there was a binding agreement, written vacation rental, those sorts of things. It's sort of akin to, for those of you who have the great fortune of being familiar with the red light camera process, you're issued a violation based on the driver's license and registration associated with the license plate. And you could say, it wasn't me, it was my kid. Or I rented it out to a friend, this is their problem. You can provide evidence and rebut that presumption, but the presumption starts with, this was a violation. Or you could say, oh, I was getting out of the way of an ambulance. I have, some proof of it, even though it's not in the video you see. And so there's things you can do in those contexts. The same is true here. And so that's how that works. But that's where what that exemption is for. It's not a safe harbor provision. If you're lawfully operating today, that after June 1st, you just can ignore it. That's not what this says. So I hope that was clear. I know I kind of rambled. Are there any questions or concerns from the commission on that? Okay. And then the last part of this, page 22 of 23, as it relates to the ordinance, 23 is the standard, this is how this is drafted, this is, severance clauses and all that stuff. So page 22 of 23 is the final provision. This was the exemption for owner-occupied vacation rentals and the affidavit that you would use to establish that exemption. And, excuse me, any feedback on that? or any revisiting of that, from members of the commission.
Oh, that's good.
So Mayor, we've completed the review page by page of the ordinance in its current draft. I do have the consensus direction. During our last occasion to convene about this stuff, we then went to the public, and I will defer to you as the presiding officer as to how we proceed.
Okay, at this time, we will open up to public comment. Every person will be given 3 minutes. You will state your name and your address. There will be no slanderous remarks made to the commission, and all comments will be about this issue. So at this time, if there's anyone who would like to come forward and speak, we would love to have you come.
And for those who are on Zoom, remember to unmute yourself once you've been acknowledged and you're able to hear.
And what we'll do is we'll go back and forth. I'm going to start with Don, and then I'll go to Zoom, if that's okay with everyone.
Mayor, if you, one second. Member McCall's taking a conflict break.
Okay.
Since we've been going for a while, you want to proceed or do you?
No, let's proceed.
Okay, thank you.
Go ahead, Don.
Okay, Don House, 2104 Beach Trail. It's kind of like chasing a greased pig, isn't it? I mean, whatever's happening in Tallahassee and changing. But I want to compliment the commission tonight. And I have to agree with Randy first. That's a dang good-looking guy on the screen right now. So anyway.
If you could just lean in the mic a little bit better. Sorry, it's just.
There's a dang good-looking guy on the screen right now. So. Anyway, I want to compliment the commission. A lot saner things tonight. I've been talking to business owners, people that own short-term rentals, people that are right around, people that hate them, and it all boils down to the noise. I think that y'all are making a big step to controlling that and applying. If you really enforce the noise ordinance, I think you're going to solve almost all the problems you got here. A couple things here. One about the getting the occupancy square footage. I think definitely should be a factor on that. Whether it's more at 2,000 square feet, 5,000. You know, actually we should really factor in square footage on this. Just don't go by the bedrooms. Houses that were built and are that large were built with city permission, with city permits. We have to take that into consideration. The older houses, we have some older houses that have been modified with permission, totally legal, and are nowhere near parking space meeting the number of parking spaces. So anything that's been permitted and old houses, we have to have consideration for the grandfather in on that. I really, when I was talking to people that own short-term rentals, I talked to a group that owns a bunch of, or represents a bunch of them, and they were very dismayed that the city would not meet with them as they were, as y'all were developing this ordinance, that we're meeting with the people that were affected by it from the residential people, but not by the short-term rental owners, and that was a little dismaying. So it's kind of one-sided that was just there. I did make a public service, public records request for all the problems that have been occurring, so we could find out where the problem houses are. There was nothing was forthcoming. Mike Kelly said we don't have certain files on these houses. We just know where the bad houses are. The city needs to clean that up, make sure that they know and can enforce what the bad houses are. So that makes it really a good. So you got a good record for when you're talking about a bad house. When the licensees talking about they cannot get their license until the inspections. We should say if they've applied, they have to have time. If 200 of these happen at one time, I don't think there's any government around that can do 200 inspections in a couple of weeks. So if they've applied, we'll assume they have the license until such time, until they can get an inspection and then correct any give them a short time to correct anything that's wrong there. I guess my 3 minutes is up. Thanks.
Very much. Thank you. Hi, Erica.
Hello, good evening.
Oh, one second.
Madam Mayor, we have nobody on Zoom at this
Okay,
time.
all right. Thank you, Erica.
Sure. Thank you,
Thank you, commissioners and city staff, Mr. Mims, Mr. Mora as well. Thank you all for
Excuse me, Erica, I need your address.
I'm sorry, 534 Harbor Drive North. Erica Dietz, sorry. I really have one main concern I hope you can consider, and that is with regard to the designated responsible person. Completely understand that when there's a problem in a house, noise or otherwise, we want to have a good response time. But speaking personally and for many owners, the 24/7 response time within 1 hour is just not physically or biologically possible. That would mean not sleeping. I've mentioned before that I think it might be a good idea to consider a hotline tied to some kind of answering service. This way, it would allow for 24/7 availability. A hired answering service company could answer the phone anytime. We could also, as a city, come up with standardized verbal responses based on the situation, so those answerers could be trained how to respond to various situations, just as our 911 call centers are. Similarly, standardized action responses, contacting the appropriate authorities or whatever might be, appropriate to the specific call. Importantly, considering the code we're trying to adopt, it would also allow us to easily track the source of those calls as well as what subsequently transpired and what the outcome was. Very similar to a 911 situation. You have to say who you are calling, what's the problem, what's the address, and then also there's some kind of record of what happened. If the city is looking, as it says in the current template, to ask people to keep a record for up to 2 years of all these things, why not put that on an answering service that we could pay? So this to me makes a lot more sense than trying to ask an owner like myself to stay up 24 hours a day and cite me for violations if I don't answer within an hour. That's just going to be really difficult. If I have one more second, I may have misunderstood, but with regard to parking, section 18-218, number 2, the permissible parking location currently says all people and visitors must be parked within a driveway or parking area located on the premises, which I think we might have stricken that with the land use code, but if not, that would also be impossible, I would think. So hopefully we're going to clarify that. Thank you again so much for all the effort.
Rod Baker, 364 Bahia Vista Drive. I call your attention to the occupancy ordinance. I would encourage you to consider square footage, big difference between a 3.2 and 1,000 square feet or 3,000. One thing you could do would be 2 bedrooms plus 2, max 10 up to 1990, and then 12 above 2,000 square feet. And here's why. For our business, we run an 8-4. We don't want 10 adults. We want 8 adults, but 4 children. And this ordinance doesn't take into account the children. 8 and 4, that's families. Oftentimes it's extended family, no noise, no problems, they share cars. You make it 10, you've just incented the owner of a family vacation rental to cater to 10 adults. That's a party vacation rental. You have the exact opposite effect of what your intentions were. Also with parking, if you encourage the savvy investors to respond with additional parking, you're going to be taking away parking from the residents. Every driveway has an apron. Every apron removes a parking spot from the citizens. The exact opposite effect of what you're trying to accomplish. You know, I understand that there has been some letters received by the city regarding all this. It may behoove us to use a scalpel instead of a chainsaw. There is an occupancy considered a loan, which might be the least risky thing for the city to do. There's standing law in another city in our county. No judge is going to want to remove standing law. I would like to have an opinion from our city attorney. What is the least risky in terms of us getting financially strapped through litigation? And maybe it's just an occupancy. Think about it. If you relieve occupancy, you relieve parking, you relieve noise. Why not just do occupancy for 6 months and see what happens? Maybe it solves the problem with the least amount of risk to this city. And once again, I would be remiss if I don't call for those unwelcoming signs to come down. I think the city should do everything in its power to, it's been a PR nightmare for the city of Indian Rocks Beach. We're on the news for all the wrong reasons. Now they're even filming cops on Gulf Boulevard. Not the direction we want to go. Thank you.
Thank you, Rod. Next. Anyone on Zoom? Okay. Hi, come on.
Hi.
Can you pull that down so we can hear you?
short on one end.
Yeah, you wanna bring that down? There you
Sure.
go. Hi.
Is that good?
Yes, ma'am.
Okay, my name is Marilyn Bush, and I live at 512 Harbor Drive North, Indian Rocks Beach, where I have lived since we built our home there in 1973. So the changes that I have noticed are not of an area where I'm out to make any money or I'm renting anything. It's just the changes that I've noticed in my own neighborhood that you may not be aware of for someone who lives there and has lived there for a long time. My golden years have really turned to brass because of the rental homes that are now right next to me and 2 across the street, with more to come. I have had to do several things to keep my property private and not overrun by renters. A couple of the things are, I've had to put black-eye blinds on my windows next to the home where it's a 2-story home and they leave their lights on all night and they shine in my bedroom windows. I have asked the owner, who is there rarely, if he could do something about that. But how do you do that with weekly people who rent there? Do I go over in the middle of the night and say, turn off the lights in the basement, only to have to go do that again the following week, and the week after that, and the week after that? I also put up a fence because our lawns are contiguous and there's a possibility that people could park on my lawn. So I put up a fence. Never intended in 47 years of living there to ever put up a fence. So far, I've spent between $7,500 and $8,000 to protect my property. These are the things that you might not think about because I'm just a resident. I'm not an investor. And that's another thing. We have gone in our street. We had a neighborhood. Everybody knew everybody. Everybody got along. If you needed anything, that's where you went. You could go borrow a cup of sugar or a gallon of gas or whatever you needed. Now, we don't have a neighborhood. We have a street. And we don't have residents, we have investors. Now the term investor, I don't have to explain what that means, but the residents are really paying the price for these short-term rentals. I know this doesn't address any of the issues which you are dealing with, but I thought you just needed to know what it's like to live next door to a short-term rental.
Thank you, Marilyn.
Thank you.
Thank you for coming up today.
Hi.
Hi.
I'd like to thank all of you again for being here and taking this matter seriously.
What's
Oh,
your
sorry.
name?
My name's Patty Katz and I live at 124 13th Avenue. I just wanted to thank you for taking the time to take into consideration of this very important matter. A couple things I just wanted to mention is that there should be and is a distinction between businesses and residents. Transients are on vacation the entire time they are here. So if it's a 7-night stay, they're on vacation for 7 nights that they're renting. Residents work and they're not on vacation. There are people clapping and about less restrictions. It just proves that they have no regard for the peace and tranquility of our residents and have a lack
of respect for the residents. About parking, I didn't know that we were enforcing parking because people park in front of my mailbox all the time. The only thing I can do is put on the mailbox, please do not park, but they still do. Granted, I'm a block from the beach, but if they're in front of my mailbox, I don't get the mail. So that's just something I wanted to point out. Right now, we're saturating the neighborhood with rentals. We're deciding, oh, should it be 12 people in a house? Should it be 10? Should it be? Either way, it's so many people, and the people are walking around our neighborhoods, so that it's not really a neighborhood. Just to piggyback on what was said, what it is they're streets, and people are walking around the streets. They don't live here. They do not care, and it's just sad for the residents that live here to see what's going on. And just one other point I wanted to make about occupants and not including children in the occupancies for a family rental. I just want to point out that right now the federal government tells my uterus when there is an occupant. I'm thinking that we should include children as an occupant in short-term rentals. Thank you.
Anyone else would like to come forward at this time? Yes. Is there someone on Zoom?
We have Susie on Zoom.
Hi, Susie. State your name and your address. Hello?
Yes, Susie Bell, 717 First Street, Unit B.
Hi.
Hello. I wanted to address earlier when Commissioner Joe McCall said about what's the difference with the pool regulations after 10 o'clock as a homeowner. It is, if you're a homeowner, it's your pool. If it's a short-term rental, it's a nightly fee. And I've never stayed at any hotel ever that the pool didn't close down at a certain time. And also, around where we live, we have the large builders for sale signs, only it says vacation rentals, which is kind of, and I think it's a lot more up north of us. You go down the streets and these big signs, and I haven't heard that been addressed. So that is my comment. Thank you.
Thank you, Susie. Hi, Jerry. Your turn.
Hi, Jerry Newton, 438 Harbor Drive North. I hope I misunderstood what happened when we talked about 18-217 quiet hours limitation, because I heard something about gutting number 1 and number 2 from the document. So if we take number 1 away, we now have no limitation of when we can have guests. We already have our 10 people or 12 people. So now we have the ability to have guests 24/7. Maybe they're not sleeping in the bedroom, they're just partying at the house. If they can be outdoors, like the caller just mentioned, so they're in the pool after midnight, after 2 a.m. We just took away all the, now refining them I'm okay with, but gutting them, you just took the whole strength away from the biggest complaint with short-term rentals, which is noise. Just eliminated it, gutted it, as Randy said. Another open door, if I'm not mistaken, maybe I missed it. Anywhere in here does it mention a maximum number of guests? There's something about I need a permit to get more than 50. So okay, I got 49. I got 49 people in my house next to this lady over here at 2 o'clock in the morning, and it's legal because we just gutted some of the major important points of this law, okay? I don't even know how else to say it. I hope I misunderstood what happened just then, but to me that was just about eliminating the purpose. Thank you.
Thank you, Jerry. Hi,
Hi, Commission.
is there anybody else
You got
again or
We
no?
do not have evidence.
Okay, you're.
Okay, thank you. Lee Wilkerson, 490 Harbor Drive North. Regarding the occupancy limitation, okay, so it's gonna be 12, and let's say the ordinance gets passed sometime this summer. That means we're gonna have 12 people in every house, because all those bookings will be made a year in advance on every weekend during the busy times. So whatever limit we put, that means we're gonna have that
We
many
don't
people.
answer back to, but I will at this, to tell you that it's 10, not 12.
Okay, so 10. So what I thought it was, I thought it was 12 for
For
sure.
the first year.
For the first year. So that's what I'm suggesting, is that if we make it for 12 for the first year, now these bookings that are being made, we're making them for 2024 now. So that means we're gonna be 12 for the next 2 years if we make it a year. Should make it 10 now. If you've already got a booking for 12, we'll allow it this year. But if you're booking for 2024, it's gonna be, should be 10 people. Pool hours. All of the beach properties that have vacation rentals, we have pool hours. They have to be posted. You should have pool hours. You should close the pool at night. That's just responsible. That's just being a responsible owner. The door posting, that's a great idea. Parking limitation, no limit to the number of cars that we can put. That's crazy. How many complaints do we have? That should be published. We should be able to see that as citizens. 24-hour service, yes, that's the one biggest problem with all of the vacation rental operators. Most of them depend on services. And guess what? If you're having guests stay in your house and they're paying you, you are responsible for them 24 hours a day. And if you've made yourself responsible for all of it, then yes, you might have to wake up and answer when the toilet's flooded. So pay for a service. That should not be something that's the town is responsible for. A vacation rental should have a yard sign. Let's see the vacation rentals. It shouldn't be on a garage door. Several of them are on garage doors, so there's 12 cars there. They got the garage up because they're out on the bicycles. I can't see the number. As far as enforcement, ask the people who've been doing the enforcement. We have hotel rooms. We know when the problems are going to occur. It's going to be on Easter, New Year's, 4th of July, and Memorial Day, and every Thursday, Friday, and Saturday night. So enforcement should really not, it's not, I know it's 365, but you can really bracket some dates and really prevent a lot of problems by just opening our eyes on Thursday night when we see the 10 cars streaming in for the bachelor parties and so on, the weekend parties. Again, we want our zoning back. We want to have, you know, a minimum 30 days or 90 days in the neighborhoods. That's the ultimate goal. So, thank you.
Hi, Kelly Cicerek, 448 Harbor Drive South. I would say that I was disappointed with the changes to this ordinance, but really that's not too strong enough. I'm really disgusted. For commercial tourists, you threw the residents who live on the west side of Gulf Boulevard to the wolves. There's no building code inspections anymore for the west side of Gulf Boulevard, and that means that there will be illegal build-outs and those properties will be packed full. If there's not annual inspections for building codes, then the interiors of those buildings, the garages, will be built out so that they can maximize how many people they can pack in. And the developers will be able to purpose-build vacation rental units because there's no maximum occupancy on that side. Bring in the bunk beds. That's what Gulf Boulevard's going to be like. There's already one purpose-built vacation rental property advertised with a sign at around 9th and Gulf Boulevard right now. For us, on the east side of Gulf Boulevard in residential zoning, I have to ask, how are these occupancy limits going to be enforced after 10 p.m.? You could have up to 49 people on site before you need a special use permit for an event. Our noise violations are all we have, but we had those before, so what did we get with this occupancy? There's no way to enforce it. And if you don't differentiate between registered guests on a rental contract and visitors that are just on site there visiting, then you have no way to control the extra people that are on site at night. Spring break brings ticketed pop-up parties every year to the east coast of Florida. And I don't see why we wouldn't have those here now too. You didn't give us anything to address this type of problem. So I think you need to go back through this draft and reinstate some of the protections for residents. Thank you.
Beth McMullen, 481 Harbor Drive South. Talking about the occupancy, I think those that are against the occupancy being restricted and wanted on square footage don't live around some of the large houses that we do. We live at the end of the cul-de-sac, and the house across the street has an occupancy of 14. 2 houses to the west or the east of us, the occupancy is 16. 5 houses beyond that, the occupancy is 12. So just in that one area, stone's throw away from our home, literally I could throw a stone, is 42 people. So I disagree with not having occupancy based on the bedrooms. And you spoke about the bedrooms not being an issue. The house across the street from me was originally built as a 5-bedroom. It's now 7 bedrooms. They've taken the dining room, made it into a bedroom. The little sitting room is now a bedroom. So, I mean, they can take these large houses and make multiple bedrooms out of them. And it is a problem to have that many people down at the end of the cul-de-sac. 42 people. And there's no restriction on how often they can come. They can be there for 3 days, and then another 42 people can come. Regarding the parking, and also occupancy. I mean, parking in Indian Rocks Beach is privileged, as we all know. We don't have enough of it. I've seen VRBOs and Airbnbs that state in their advertisement, parking for 2 cars. I don't really see why we have to, just because they expect it, we have to give them all this parking. It is what it is. And if it doesn't meet that rental's needs, that person trying to rent, then move on. Find a place that does meet your needs. In the meantime, plan ahead. Fly in, get an Uber, use the public transportation that we have, but you have a restriction, and you have to maintain that restriction. We don't have to give you parking. I don't really see why it's necessary. And the same thing with the occupancy. Some people say, I've heard it at the meetings before, oh, but my family has, I don't know, 12 people, and then I should be able to find a place that has occupancy for 12. No, it's not necessarily a given. If I find a place or I look into a place and I want to go stay there, and it doesn't meet my needs for my family, then I go to a different town. I find something else that actually meets my needs. Just because you expect it doesn't mean it has to be given. So that's my point.
Hi, Preston Smith, 2308 First Street, unit number 5. The vast majority of our long-term residents need this city commission to discourage and restrict the short-term vacation rental takeover of our city, specifically Airbnb. And so I was very surprised that you removed some of the restrictions on the 23 pages of the new ordinances today. And that, yes, some of them do not seem to make sense. For example, one family can be in their swimming pool while the other family is not allowed to be. But for the long-term residents here, it makes perfect sense because they are more respectful and more used to the quietness of the neighborhood, whereas the vacationers, they should get out of the pool because they do not have the same respect for the neighbors in the city. I think that the 1 hour response time for the responsible person guest is a pretty radical rule. I think that will help a lot if we keep that in there. And so I was kind of concerned that we had so many of these radical rules all of a sudden, like the 3 violations and then the removal of the rental registration, that maybe it wasn't such a good idea to put them all at once. But I do think that the long-term residents, yes, we need to be fighting back against the short-term vacation takeover, which is also, it seems now, it's kind of disheartening. We can do all this talking, but Tallahassee is going to take it out of our hands. And they seem to be siding with the short-term vacation rentals as far as restricting the amount that, the length of stay. And so I would like for our city and commission we need to tell Tallahassee we want to control these and to stop taking campaign contributions from Airbnb and then writing these rules that, do not help our city. But I do think that the occupancy limits was a great idea. And then as far as just to discourage people, the corporate investors, from buying these houses and turning them into short-term vacation rentals, things like the parking restrictions and these different kind of strange restrictions, I think that will help our city to preserve our small town community for future generations. Thanks.
Land Bond, 301 Harbor Drive, Indian Rocks Beach, Florida. Want to thank the Board of Commissioners. This is a far cry from where we were 6 months ago. I've had the opportunity to talk to Greg. Some of the initiatives you guys have put forward have been outstanding. I am disappointed tonight. I'm disappointed because we have seemed to have forgotten that we are the residents and short-term rentals are commercial properties operating in our neighborhood. I had the opportunity, like Don, to talk to several people, door knock, find out what our people want. I've had the opportunity to speak to several of our boutique hotel owners. They are okay with these regulations. It puts them on a level playing field with our short-term rentals. They need to actually be accountable like our hotels. We need to inspect the short-term rentals and make sure that our citizens are safe, our tourists are safe, and we are working together to make sure that that happens. Thank you.
Hi, I'm Mary Wilkerson, and I reside at 490 Harbor Drive North. Obviously in Indian Rocks. A couple of things. And we've sat through several of these meetings. To me, the goal, and I hope it is the eventual goal, and I know we have challenges in Tallahassee, is to enact regulations that act as a deterrent to having short-term rentals take over our neighborhoods. I mean, that should be our goal. Can we do everything possible to make that happen? Yeah, I think we should. I don't think we should gut some of the things you talked about, the 10 persons, the parking, so forth. Do everything we can do. Again, we can't, Tallahassee moves slow, so there's not a lot we can do about that. With the exception of, we won't go into all that other community stuff, but the city needs to be serious, I think, about imposing fines, penalties, and the teeth to me in this whole thing is the eventual elimination of short-term renting privileges. We have, I think you know, we have small boutique hotels. Some of the historic properties, we own 4 different historic properties and have, starting 35 years ago, buying small properties and maintaining them. And we are preservationists and we love our small cottages. And when Airbnb was introduced, there was a very uneven playing field. They were allowed to, well, they didn't have to pay taxes. That was the first thing. That was the first fun thing. They didn't have to pay that 13%. They could put as many people as possible in their places. Certainly doesn't have any pool regulations. There are still no pool regulations for Airbnbs in the residential area. Certainly we have those things. So again, unfair playing field. If, like Mr. Bond said, what makes Indian Rocks interesting and gives it a sense of place is these small cottages and the historic properties and things. And if you continue to allow these large investors to sort of go around the rules, act like hotels, but not follow the rules of hotels. We have state license, county license, city license, and all the hoops that we have to jump through on the west side of Gulf Boulevard, but not on the east side of Gulf Boulevard. So again, unfair playing field. I'd like to see their pools regulated like our pools and their regulations that we have to follow, that they need to follow. If they're going to act like a hotel, they need to have the same rules as we have on the west side. Thank you.
Good evening. No, everybody probably wants to get out of here. Todd Shear, 456 Harbor Drive North, and some of the other folks already spoke on some of the topics that I had planned on speaking about, but in regards to parking, and that's obviously a hot topic. There are communities that just outlaw overnight parking on the street from like midnight to 6 a.m. or midnight to 7 a.m. It would apply across the board. But that is one solution. That's obviously something that could be enforced as well. And that can be an outcome that could be positive for the community, for both sides of the equation, frankly. I do rent my home. It is my family home, and I rent it. And my kids love this place, as I mentioned before back in December. But, that's one solution we could consider in regards to the parking situation.
Thank you, Tom. Is there anyone else who'd like to come forward at this time?
Good evening. John Fansteel, 448 Harbor Drive South. I appreciate what you have done, but like Kelly and a couple other people, I'm really disappointed that it's been gutted so badly. I don't even understand some of the logic behind it. For instance, gutting no visitors after 10 p.m. If you have an occupancy of 10 and there's 24 people in the pool or in the backyard, it's easy to police. I mean, it's not always easy to police if everybody's inside the house, but just because it isn't perfect doesn't mean you should throw it out. As has been said by other people, of noise, parking, garbage, noise is probably the biggest. And noise comes from having many, many guests and parties going into the evening and in the pools. So definitely should put the no visitors past 10 p.m. and the pools back in it. I mean, that's the source of so many of the problems here. And trying to compare people in one pool that are residents versus people in another property, perhaps adjacent, that's not residents. Again, it's been made the point that the people that are residents work. They have to go to sleep. Whereas the people that are renting, every week you get a whole other group of people partying there. So there's no need to balance those two things. They're so different. And the final thing when it comes to the signs, we all know, I don't think there's anybody up there that would say that short-term rentals should be in residential neighborhoods. Residential neighborhoods are carved out for residences, not for businesses. The signs will come down when there's no short-term rentals in residential neighborhoods in Indian Rocks Beach, like it was intended to be, and like when we had a 3-month minimum. We're going to fight to get that back. Thank you.
Hi, I'm Teresa Krupniewska, 166 Daniel. I spoke with some of you and I heard something and I was praying to God, well, I heard it wrong and it's not true. But it is. I was so hopeful that you elected people would protect residents. You know, we let it go through hell. And the investors just came into our communities, our neighborhood. They destroyed it completely. They ripped all the rights and privileges we had as a residing on that street. And if we don't stop this, that will destroy the entire community. There'll be no residents at all. This is such a big danger. We're changing society as we know it by letting those investors to come in and destroy our communities. They're not even hotels. They're tourism hotels. Hotels are very respectful. They watch they have rules. Those people are without any rules, without any respect. They come in, they take a single family and they flip it into double the bathrooms and double the bedrooms so they can squeeze the most money out of it they can. They don't care about the neighbors, about the noise, about the parking. They don't care about anything. All they care is the dollar. And that's what I hear from some of you. The dollar is what you are falling for. And dollar leads the way to all these problems. And dollar will survive. It seems like you letting the dollar win, the investors to come in here, take the money and destroy us. And we elected you to protect us. You're not doing it. Today is obvious. And I was so hopeful. You're letting us down. You're following the dollar. What a shame.
Yes.
Hugh Burton, 1102 Beach Trail. I'm just going to repeat or dovetail on two things people have said. I've lived in this area since the late 50s. I've seen Indian Rocks Beach being a sleepy beach town. And the reason I built my house here several years ago was because it was a sleepy beach town. I could have done it in Clearwater, I could have gone to Lauderdale, could have gone to a number of places. If I wanted to live next to a hotel, I would have done that. I elected to be here because it was a residential neighborhood, in my opinion. But I think there is a solution. And I know much of this is handled by the state. There's probably not a lot we can do except manage it as best we can. But I think it comes down to common sense and responsibility on behalf of the short-term rental owners. Perhaps they should be required to live next to the property they're renting out.
There you go.
No more clapping. No more clapping. Thank you.
Hi, good evening. My name is Marty Ryan, 402 Hart Drive. I am a regular volunteer at the county shelter, and I'll just let you know that if we need to borrow any teeth from some of those homeless dogs to put back into the ordinance, we can easily do that, because we really need some help. I'm so tired of hearing the residents victimized and the short-term rentals portrayed as the victims. The only PR problem IRB has is getting the reputation as a place where anything goes. And you've turned a treasure into a train wreck. It's terrific. Great. We do need your help to push back on Tallahassee. And we'll back you. We'll back you. And my heart really goes out to my neighbor who built in '73 and is watching her golden years turn brass, because I feel that every day. I worked so hard to be here and stay here. And this is what I have to look forward to. And I know you know what's going on. But I write to you and you don't even have the courtesy to write back. I know she have an RFP for a website. Maybe you can put an automatic reply on there. How disrespectful to your constituents. And I would counter to the person who says they can't answer a call 24/7 with the fact that you cash those checks 24/7 and at our expense. Enough. Our homes are our sanctuaries, and we will fight for them. And we'll fight for you. Just please help us. Thank you.
Is there anyone else who'd like to speak at this time?
Sarah Johnson, 1206 Beach Trail. Carol McLaughlin at 115 21st Avenue has kindly yielded me her time.
Is Carol McLaughlin present now? Stand. You yielded your time to her?
Yes, I have.
Okay, thank you.
If you live west of Gulf Boulevard and are surrounded by condos and motels, you dodged a bullet. The rest of us can, and probably have, filled you in on the nightmarish reality of life behind a single-family home gone vacation rental. Condos and motels have rules stated and posted for a reason, to protect all those residing and staying there from others who would disturb the peace. But we woefully found when the single-family home turned vacation rental next to us 5 years ago, when asked to put rules in place that would allow us some sleep at night and some sanity during the day, the owners of this mega rental, catering to massive, ever-evolving party entourages, took the attitude, yeah, no, we don't have to do that. When Chief Davidson recounted wanting to purchase a home in IRB but decided against it because he could not effectively do his job without sleep due to vacation rentals, his words, I'm sure, echoed the lived experience of many of us. Me, or RB, over the railing, after midnight, on a continuous basis, new week, new group, new request. Hey guys, it's a weeknight. There are families right beside you. People have to work in the morning. Could you please take it inside? Could you please quiet down? Shocked, perplexed, outraged, the response more often than not is, weeknight? What do you mean weeknight? West of Gulf Boulevard is not the business district that the vacation homeowners of IRB would like to have you believe per their letter, which I also received. It's not Bourbon Street. It's not your personal after-hours club to stumble into to top off your night after the bars close for a hoot and holler and rounds of cornhole, a hilarious game of beer pong, followed by 8 people in the hot tub singing along to Paradise by the Dashboard Lights. While half a dozen more people are telling each other drunk stories, shouting no way every 5 minutes on the massive outdoor living room deck above. Oh my God, turn it up, that's my favorite song. We're on vacation. Every night, every day, all day long. Why? Because the mindset is we're going to get every penny's worth out of the fun that we spent $12,000 on this rental for this week. It's our right, we paid for it. Commissioners, no one, not even those of us on west side of Gulf Boulevard, should have to spend their life dreading Saturday turnover, wondering if the next group could possibly be more raucous than the last, dreading Sunday fun day, and worst of all, Sunday night, when they've stocked up the bar, feel like they've got their sea legs on, and are really ready to let loose. Meanwhile, for the rest of the world, as we know, Sunday nights have an entirely different meaning, getting yourself organized and rested for the demands of the week ahead. No, west of Gulf Boulevard is not the business district. It is commercial tourism, a place where residents and tourists expect to be able to process a thought during the day without finding there is nowhere in their home they can go to escape the never-ending party music. A place where residents and tourists alike expect to be able to sleep at night. The root problem is greed. Greed for money the owner can amass, and the vacationers' greed for the no-rules party house they've bought and feel is their entitlement. And greed blinds people from regulating themselves. They do not give a rat's behind for the city and the neighborhoods they are decimating. The only resolution is to pass an ordinance clearly delineating behavior that is not allowable on the premises of these businesses. Businesses that are willing to behave in a responsible manner have no problem with rules because the rules don't impact them. They are already behaving responsibly. Both RB and I own vacation rentals west of Gulf Boulevard. The cottage always has and always will be quiet. My rental, not yet operating, will have strict rules guests must sign agreeing not to disturb neighbors. Why would I impose these rules knowing it will turn some renters away? because of basic human decency. Because my neighbors and the city matter more than my ability to make money off the partying segment of the potential customer base. The day that IRB became a city that is undesirable to our own fire chief and countless decades-long residents and families who have had homes here close to 100 years, we know our city has gone astray. We desperately need proactive ordinances for all residents' quality of life, including taking us out of perpetual reactionary mode. As a commercial entity in a residential structure, the burden needs to be placed on the owner and the renters to ensure quiet. The burden should not be on residents to repeatedly ask for enforcement. Continuing to allow unsupervised neighborhoods on the west side of Gulf Boulevard emboldens the vacation owners of IRB opposed to rules to say, hey, see, we can make these neighborhoods unlivable for residents, and they can't do anything to stop us. Unlivable. The city's residents might leave. Great, they'll say. That'll open up all the more properties we can scoop up and turn into greed factories. Commissioners, we need your help. We need you to protect us from unsupervised short-term rentals throughout the city, including west of Gulf Boulevard. Please do not let the vacation rental industry steal our beautiful city from us. Thank you for your time.
Thank you, Sarah. So thank you all for
Hello, my name is Gorman David Ludwig, 2312 Gulf Boulevard, Indian Rocks Beach. My viewpoint might be a little different than the majority of the room tonight. My family's owned our property since the 1930s. My grandmother rented a man back in the 1960s on a short-term rental. And that man married my mother, and I exist because of that. It's part of the village history of Indian Rocks Beach, people coming here to enjoy. And I understand a lot of the complaints about the short-term rentals, and I feel the pain because there's some bad ones out there. But they're renting homes, they're not renting hotels. And when we rent ours, we rent our home. And I've never had a complaint in my 11 years of renting it, or 12 years of renting it. And usually the only complaints that ever happens when I'm actually there having parties, because I like Sunday Funday. And but people rent homes, and I think they should be treated as homes, and I think that owners should be responsible. I like the changes that were made to the rules, except for the pool rule. I think everybody should have equal pool rights. But the ordinance that exists already are not really enforced, and I think that if we did enforce them, I think we would all be happy. So I like the rules, and I hope that people do understand that families come here to enjoy Indian Rocks Beach, and I think that putting too much restriction really hurts the families that want to come here. And I think the gentleman said earlier that you put the 10 there, the families don't come, it's mostly partying adults. And I purposely don't like partying adults at my beach rental. And I don't even allow cigarette smokers on the property because that's the biggest littering on the beach. So I impose that rule on our property to keep the littering down on our beach. But I love Indian Rocks Beach, and everybody in here loves Indian Rocks Beach, and I think that we should be a little bit more welcoming to the guests of Indian Rocks Beach. That's it.
Is there anyone else who wants to speak at this time before I close the public hearing?
My name is Mary Levine. I live at 306 Vigia Vista, and I sent a letter about a month ago about the infrastructure of Indian Rocks Beach and how it's being handled. And I was watching Bay News 9 on Monday. We have 28 city blocks, and the traffic is so dense, our fire department can't get through. That's pretty alarming. They want another fire department. So I think we all should start thinking about exactly how much the capacity is and how many people are here. Thank you.
Thank you. anyone else would like to come before I close the public hearing?
Maybe I'm lost, I don't know. Rick McFall, 408 Harbor Drive North. How are y'all doing this evening? I am again also a little bit kind of interested in where we've gone with this whole function of things, is why we're here and why we're holding these workshops. I think part of the thing that people have to remember and stuff is that you know, this change happened in 2011, and it was a big surprise for everybody. And it was addressed in around 2014 here, and there have been problems ever since then. But the problem is there have been voices expressing their concern about these developments and all that since 2014, but have been largely ignored. We have no records of complaints. We have no records of interactions, and in fact, in most cases, most of the residents, as you're hearing with some of the people here tonight, are saying that you know, they write letters, they write stuff, and they get no responses whatsoever. So what it tells me is, it leads to believe that there are there's a lot of noise, a lot of residents out there that are pretty much just giving up complaining because they know it doesn't do any good. They have better things to do with their time from that standpoint. And so here we are now. We've had, you know, this is the third workshop, I believe. We've had a great deal of discussion and all that, and we're right back to the same situation where, again, whereas we write something and then at the last minute we decide to change it and maybe water it down because somebody doesn't like particular positions. I think particularly the quiet hours limitations, I think that they're reasonable. There may be some adjustment, but let's look at the reality of the situation, even regarding these. There's nobody roaming around the neighborhood from the city that's going to be out 24/7 looking at this stuff. This is complaint generated, as City of Indian Rocks Beach has always been. Somebody has to pick up the phone and complain before there's any action whatsoever. So this footprint here is basically a minimum standard. It doesn't mean it's going to be used in all cases, but if somebody's having a pool party next door at 12 midnight or 2 o'clock in the morning, and they need some relief from that, this at least puts it in perspective and allows somebody to go out there and say, hey, knock it off. Otherwise, if they're quiet, nobody's going to waste their time complaining. I mean, I'm not going to wake up at midnight or 2 o'clock in the morning and go look over a fence and see if they're in the pool or not. But I am going to be concerned if they are waking me up, you know, from a standpoint of because of the noise, and from what I'm hearing, we're going to water this down, and then there's absolutely no provision whatsoever to be able to take care of it. So that and the parking regulations, I think, are the whole reason why most of the residents were here with this groundswell of complaints and filling up city halls and all that. And I would really encourage them to continue to look at this and leave those provisions or something close to that in place. Thank you.
Thank you, Rick. Is there anyone else who would like to comment?
R.B. Johnson, 1206 Beach Trail. I agree with a number of the previous speakers who seem to be disappointed that there's been a move tonight to somewhat gut the regulations that would have proactively protected the residents. And the operative phrase is proactively protecting residents so that they don't have to always be reacting. That's a large part of the problem. And the pool regulations that you were contemplating, and then pool and hot tub regulations that were in and then now seem to be out again, really, you know, puts a focus on what the problem is, or one of the problems. If somebody is in a pool at an inappropriate hour, or a condo or hotel, they're not supposed to be there. There's rules. They're basically told to get out. That should automatically be the same kind of standard, I'd say, throughout the city, but definitely, of course, in the residential neighborhoods. I think it should apply in the west side of Gulf Boulevard. My wife has already said we've had problems with the same kind of behavior. We just had to call the sheriff's deputies a couple of weeks ago because 4 women were in a hot tub at 11:30 at night on a Tuesday night and woke us up from a deep sleep. And yes, the sheriff's deputies were able to come and talk to them. Quickly they arrived, but they couldn't tell them to get out of the hot tub. So they quieted down, but we could still hear them. This would not be happening at a condo or a hotel. And these places, these single family homes are mini condos and hotels without those rules. And this is what the problem is. It's forcing the residents to constantly react. It sounds like we could be in a position where we could call every single week of the year because if there's noise complaints, and I'll say, for instance, a hot tub or a pool next door to us, and every time there's just a warning given for that group of people, the next week there's a new group of people, another warning, the next week another, where essentially there's no real consequences. They're not getting tickets, it's not getting added up, so that there eventually will be that hammer that will come down and say, hey, you know, you're going to get into a situation where you're going to have a suspension of your ability to rent these places. So I think that needs to be really taken into consideration here, that the residents should not always be having to react and constantly be getting on the phone. And by putting these minimal restrictions in here, and I think of them as minimal, it's putting the burden back on the renters and the owners, where it should always be in a city like ours. For them to be following the minimal baseline rules, and sometimes they're not going to, and then a resident's going to have to pick up the phone, but basically saying that we're falling back on the noise ordinance at all times and forcing the residents to react again, and sometimes not even getting long-term relief through a special magistrate, et cetera, which I have another, questions about how that's going to work. But I think that you can hear this frustration in the audience, because it sounds like, once again, things are getting watered down, and it's just falling back on, oh, we already have stuff in the code, let's just use that. But that's reaction mode, reaction mode, reaction mode. We need to be proactive. Please think in those terms. Thank you.
Is there anyone else who'd like to come up this time before I close the public hearing?
Good evening, Dave Mott, 446 18th Avenue. Thank you all for your service. Thank you, law enforcement, for your time and for your service. Thank you, Greg, for your time with our city. This is what I love about our town. I've been a resident for 11, 12 years. This is what I love about it. People care so much. People want it to be a great place to live. And, it's changed. You got a city with a tagline, world's safest beach. In your time, Greg, you're going to have to figure out when that's not true anymore. What are you going to do with that? And I think you all have to contemplate that too. It's a beautiful town. It's a wonderful place to live. And, Action 2000, the Homeowners Association, so many people are involved. So many people commit their time to that. And those are the people that are here, are standing up and saying, don't forget about us. Because the influences, there's been rentals for decades. There haven't been problems. But lately, the last 8, 9 years, it started to become a problem. As a commission, that's when you say, what can we do? What's our responsibility? I'm grateful to all of you for your dedication and your volunteerism. I just ask you to, the stories you listened to tonight, you've listened to for the last several months, you took time to act on it. That says a lot about you. Just recognize that this is a moment where you can make a difference. It isn't about rentals. It's about people that take it too far and don't care. And you have a chance to make a difference right now. I just express to you my hope that you don't just get it done, you get it right.
Last call. Is there anyone else who'd like to speak? I'm going to close the public hearing. Captain Liner, is there anything else that you'd like to say tonight?
No, Mayor, thank you.
Thank you. Mr. Mims?
Mr. Mims. Wow. I'll address 3 or 4 things. comment about the city's outreach to different organizations, particularly the vacation rental. I can tell you very clearly that when we started this process, the city received an email by a gentleman who represented or started one of the organized groups of vacation rentals. The first meeting that Randy and I had, and his whole concern or the gist of his email was that they wanted to be involved in the process, and he illustrated some other concerns he had. Before we concluded that meeting, we called him and got him on the phone and said, everybody's important, everybody's opinion is important. During the process of working on the ordinance, feel free to communicate with the city. We encourage him to email the commission members with his comments later on. I had a phone conversation where I actually called the guy back about a month later and said, look, we're not into this. The first draft or the first material was put out. We want your input. Never received it. The gentleman who's been in a couple of meetings, who's an attorney that represents some portion of vacation rental operators, I know Randy Moore's had one or more conversations with him where they've gone over every aspect of this. We can continue to encourage that input. That's why we provided soon for these meetings, is to encourage everybody to participate in it. I can only speak for myself and the people that work for me, is that we respond to every complaint we get. We respond to every email that we get. And as a result, that's why you get the monthly report about the number of people that have been cited, been warned and cited. And most people are good people. The majority of people that we deal with, and this is true for any city, are going to comply when they know what the issues are. One comment was made about a report listing all the complaints. We have records on every single complaint that we deal with. Mike Kelly showed me a 3-year comparison of file folders for the last 3 years. First year when he got started, it was about this big. Next year's about this big, and this year's about like that. We know where the complaints are. Part of the thing that we talked about back in November was, and y'all gave, back in the census, y'all gave me the ability to communicate and negotiate with a host compliance company. We're still working our way through that. What a host compliance company would do for the city, it's a budgetary thing, and when I get the final number, I'll bring it back to you, because I wish I would authorize it. But a host compliance company, all the companies we talk to, what they provide is as a tier 1 level of what you get when you sign a contract with them, is a 24-hour number that you call that number. You tell them, any citizen has it. It's a number we publish on the website, put it on magnets, put it on whatever you want. It's 24 hours a day, 7 days a week. If you have an issue with a vacation rental, you tell them where it is and the problem you're having. They have the same database that we have. They pick up the phone and they call the responsible party for the existing ordinance and the one you're considering now. And they call that number, that person, and say, here's the issue we were having. You need to respond and fix it. What the issue is. There's a record made of that. There's a follow-up report that goes to the city. They even have, with these companies, they have our form of letters, whether it's a warning or a notice to appear, that they're 24-hour operator. After they talk to the operator with vacation rental, they forward a letter on our letterhead to the operator, reaffirming we've had this conversation. It's all documented. And the monthly reports and communication are generated out of that, so that's one of the benefits of that. We'll be bringing that back to you. I can't emphasize enough, because I share the frustrations of the change of IRB, and that ultimately people legally can do what people legally can do, but we seem to be, one thing we seem to be avoiding for some reason is that the city attorney mentioned to everybody early on that there's been a bill filed, Senate Bill 714, and the sponsor of the bill is Senator Nick DeSiglia, who lives in Indian Rock, Florida. And that's one of the concerns I have about the future and our growing cost with dealing with this issue, whether it be a host compliance company, a magistrate, there's costs that go along with all that. And then the city attorney's staff, the additional time. So on those occasions where we have to go for a magistrate, somebody from Randy's firm has to come in, so there's additional cost. But back to Senator DeSiglia. He's the one that's filed Senate Bill 714. Senate 14, one of my many concerns about it is that it caps the registration fee at $50. We're looking conservatively between a magistrate, a host compliance company, and other associated things involved in that, at a minimum of between $150,000 and $200,000 more a year to fund those things. So the passions that I understand, I agree with, that I've heard the last several months, I would ask if you have a problem with Senate Bill 714, the local number for Senator DeSiglia is 727-563-1910. 727-563-1910. The Tallahassee number is 850-487-5018. The city is not proposing Senate Bill 714, but Senator DeSiglia is. And this is speaking from a city manager's perspective and balancing budgets and proposing budgets, those kind of arbitrary caps made in Tallahassee when they have no clue what expenses cities go through to deal with enforcing regulations. That's going to completely undercut us. And if the ordinance is adopted and we need these pieces to make this work, we're going to have to fund it. And the $50 cap that's in that bill is an issue. The last thing I'll say about the bill that's concerning is the mandated 15-day time period for the approval. There's just things that come into play that could be a stretch, particularly on the front end of implementing. So I would encourage the public that has a passion about this topic to reach out to Senator DeSiglia and ask him to pull Senate Bill 714 to put further restriction on our ability to make our own rules here, to set our own, let the commission set their own fees. And he also has a web address that you can look up. But, I did want to address this.
Thank you, Greg. I'd like to give the commission, before we adjourn, I'd like to have you look at, not tonight, but the next time that we come before the board, you can look at 18217, and if you come up with two that we, 1 and 2, you come up with something, or speak to the attorney about it, the timing on those two.
Well, I guess this is where I'm confused. I mean, if we're setting the max occupancy of 10 people,
Well,
you can't have 10 more people over.
Okay. Can you please just do that for now?
Okay.
And the other thing is, as far as the year out, have a discussion with Randy privately about that, and maybe we can do something about that. Those 3 things at this time. And when we set our meeting, whenever the next one is, that you come back with all of the other things that we did for the ordinance, then we'll have a discussion on those 3 pieces, okay?
Mayor, unless you schedule another work session, the next time you'll see this document will be at a public hearing.
That's fine, we can change it then.
Yeah, okay, I'll just make sure that you.
No, I know that, but we could change it then if we had to, those 3 things, okay? If you choose that. If you don't choose that, that's your prerogative too. And I'm not trying to pressure you, but,
Sorry, I missed one.
1 and 2.
And then the vesting period of the 1 year
the exemption for contractors, contracts entered into prior to enactment.
Okay, all right. Now, I thank all of you